bundle, that's DD25B. And we had been looking at those communications between yourself and Mr. Vosloo. You'll find that at page 746 of Exhibit DD25B. Oh, sorry. There seems to be an objection.
Chair, I'm not objecting. I just want to put in a reminder before we adjourned. There had been a request from Ms. Hofmeyer that Ms. Memela should find the original minutes.
Yes, no, that's fine.
They have been found. I just
Okay,
want to
that's fine. Yeah, some of these you can just make a note and give to her, and she will then run with it. Okay.
Thank you, Chair. Ms. Mamela, you'll see at page 746, do you have that? I have it. Ms. Mamela, if you'll put on your, your microphone.
Sorry.
So I just want to get the chronology right to recap where we left off. Is it correct that on the 21st of June, after your meeting with JM Aviation, they send back the reviewed price, and that's what's contained at page 747? Is that correct?
Yes.
And then it seems on the 7th of July, Mr. Vosloo is sent by Mr. Ayres the offer to purchase. Is that correct?
That's correct.
And then you respond, he forwards that to you a few days later on the 11th of July and asks you whether you agree to this and that we issue the invoice. And then you respond to him on the 11th of July, yes, Stan, that was the review price. Is that correct?
Okay, which part I must agree on?
Just the chronology. So what happens is they send the review price back on the 21st of June.
Yeah.
They then send an offer to purchase on the 7th of July. Is that
Yes,
correct?
That's correct.
Mr. Vosloo engages you on the 11th of July to understand from you whether you agree to that price and that an invoice be issued. Is that correct?
That's correct, Chair. What I wanted to find out was, because she said the offer to purchase was forwarded to me, so that's why I wanted to be clear.
Yeah, no, she's coming to
Okay.
what she wanted you to confirm.
Okay.
And then you confirm for him on the 11th of July at page 746.
Yes.
Yes, Dan, that was the reviewed price, correct?
Correct.
And then in your evidence just before the break, you said you understood that you didn't have the authority yourself to agree on the purchase price that would be paid, and so you had some engagements with Mr. Peary about that. Is that correct?
Yes, I did not have authority.
And you did speak to him about it, is that correct?
Yes.
Did you speak to anyone other than him?
I wouldn't remember, Chair. I wouldn't remember, but I'm sure I would only speak to him since he's the one who actually instructed us.
Right. And in terms of the chronology, can you place it in time? Was it somewhere between the formal offer on the 7th and your confirmation on the 11th of July?
Okay, the email from Ms. Sokulu was on the 21 June 2016, where she was coming back with the feedback on the price. And you can see then Jules sent an email to Stan on the 7th of July, I think maybe a week or two after, yes. So Chair, Stan forwards the email to me, or maybe sends the email to me with the same subject on the 11th of July 2016.
Correct.
And saying this is the only information I received on the sale of GPUs. Remember, Chair, there is nowhere in these emails where it shows that I had actually given Stan Vosloo a background on the sale of GPUs. Yet when he writes to me, he says this is the only information I received on the sale of the GPUs to Swissport. Do you agree to this and that we issue an invoice as per below? And I say, yes, then that was the reviewed price.
Yes, so I was asking when you likely spoke to Mr. Peary about it. Was it somewhere on the 11th? Was it prior to that? What do you recall?
I don't recall, but like I'm sure that I spoke to him after I had received an email from Ms. Sokulu. The reason for that, I don't know if you will allow, because then it will give clarity to you in terms of the minutes that I wanted to refer to earlier on.
Yeah.
Which will help me answer the question of Ms.
That's fine. Those would help you to have
Yes,
a better
Chair.
idea when you might have spoken to him.
Exactly.
You would have spoken to him. That's
Yes,
fine.
Chair.
Let's do that. What page are they?
I will give you the page just now, Chair.
Yes, okay.
It's the file Exhibit DD25A, Nontsasa Memela. Chair, it's page 193, file DD25, NM, page 193.
Thank you. Yes, can you pick up the part that reminds you, that helps you, that will help you to say when you would have spoken to the acting CEO?
Okay, the part, Chair, it's not like really reminding me of the date when I spoke to the acting CEO, but it reminds me that I spoke to him based on what was discussed on the board meeting, during the board meeting.
Oh, so the minutes help you confirm that you did speak to him?
Yes.
But as to when,
I don't
you are not sure?
Yes, sir.
But it would have been after you got the email
After
from Ms. Sokulu?
Yes, Chair.
Okay.
Thank you. Ms. Mamela, one last point of recap. You indicated that there was no other correspondence between yourself and JM Aviation after you received the email from Ms. Sokulu on the 21st of June. Is that correct?
I said I don't remember if there was any communication, but I don't remember accepting the offer as final, because I don't have that authority to accept the offer as final.
Indeed.
Yes.
Can we go to in Exhibit DD25B, page 616?
What's the page number?
616, Chair.
616?
Yes, of DD25B.
Okay.
Page?
616.
Is it DD25B, the Nontsasa?
Apologies, we are out of order again by one, so please go to your page 615.
Just tell her the exhibit number.
It's in the same one,
25.
DD25B at page 615. What is this document, Ms. Mamela?
This is the disposal of South African Airways technical diesel-operated ground power units. This is the document that is sent to either the bidder or the person who's won the bidder or finalized on.
Right, and did you author this document?
Yes, I'm the author of the...
And who is it addressed to?
It's addressed to Attention Nkosi Sokulu, JM Aviation.
And the date?
The date is 22 June 2016.
The day after you got the review price from JM Aviation, correct?
Yes.
Will you read into the record what you said to Ms. Sokulu in the first line?
Dear Ms. Sokulu, your proposal for the purchase of the GPUs on behalf of Swissport was approved by the Board of SAT that in accordance with the contract between SAA and Swissport. Kindly note that the approval is based in the latest price review by yourselves.
And carry on.
We hereby extend our congratulations to both companies and look forward to a mutually beneficial business relationship. Should you require any further information and clarification?
Thank you.
Yeah.
Thank you. Ms. Mamela, your evidence this morning was that you did not ever understand JM Aviation to be acting on behalf of Swissport. Why did you say in your letter to JM Aviation on the 22nd of June 2016 then that you understood that they were purchasing the GPUs on behalf of Swissport?
Chair,
Yes.
I did not say I did not remember them acting on behalf of Swissport. The question was this morning from Ms. Hofmeyer, how did I know that JM was the agent of Swissport? Did we raise that during the meeting? And I raised that on the 21st of April 2016, before the board meeting, the proposal was sent to the acting CEO, where they were actually proposing the what you call
purchase.
it, exactly. And then when Asin was responding to them and saying, okay, we will get back to you after the board
Board
process and EXCO process, like, once they get approval, like, they will go back to JM. So I never said like I did not understand them as, I said like that was picked up from there, because that's why Asin, after the board approval, he gave us an instruction to negotiate. So I'm not sure what
Ms. Mamela-
part you didn't.
You also said, I think you had an issue with the term agent,
Yes,
and you said you understood them to be a
BE
BEE
company.
partner or
Yes.
or component and so on.
yes, Chair.
Is that right?
Yes, that's right.
Okay.
Yeah.
Ms. Hofmeyer?
Ms. Mamela, the transcript will reflect the evidence. I recall the question being put to you by myself first, and then the chair in particular, whether you understood them to be acting on behalf of Swissport. That's after we had the debate about the agency. Is your evidence now that you did understand them to be acting on behalf of Swissport in their negotiations with SART?
Chair, there was even a point that I made that we were not aware that they were going to resell to Swissport, but we understood that like as the BE or subcontractor of Swissport, they would operate them as the site was operating them at that time. Ms. Hofmeyer went as far as asking me about the 30% set aside, that if I thought it was them, did I then agree with the 30% set aside? Since on Friday, as I had said, I did not agree with it legally. So I'm not sure, like, I mean, where exactly he is.
Okay, let's try and get clarification.
Yeah.
What is your answer to the question whether you knew that they were acting on behalf of Swissport?
Okay,
Were you aware of that? Were you not aware of that at the time?
okay, Chair. Remember, after the board resolution was sent to us by Asin Malola Piri, I even said, he sent me the board resolution, he sent me the proposal that was sent to him.
Okay, hang
And
on.
then plus the third one.
Yes, hang on,
yes.
Ms. Mamela.
Yeah.
I want us to go back to just before lunch where you were able to give very crisp
Give straight,
answers.
okay.
Yes,
Thanks, Chair.
The question is, what do you say now? Were you aware or were you not aware at that time that they were acting on behalf of Swissport?
I was aware based on the proposal, Chair, like
Okay.
I said before lunch.
Okay, all right.
Did you make any inquiries from them about what Swissport was willing to pay SART for the GPUs?
I did not make an inquiry on that because remember you made me read, in fact you read the provision before break that it will be sold to the Swissport PE company. So, yeah.
Ms. Mamela, we don't need to have a legal debate about what 8.1 and 8.2 means. It doesn't say in its terms that Swissport is going to procure the GPUs through the BEE company. All that I'm getting clarity on now is a matter of fact, whether you ever engaged with JM Aviation as to what price Swissport was willing to pay SART for the GPUs.
Chair, I wouldn't ask that question because Swissport did not make any proposal, or I was never given any instruction by the acting CEO to discuss with Swissport.
And then you go on in your letter to JM Aviation the day after you've met with them to say, kindly note that the approval, that's the approval of the board, I take it, that you were referring to in the previous sentence, is based on the latest price review by yourselves. Do you see that?
Yes.
Had you communicated with the board about whether they agreed to this price review that you indicated to JM Aviation on the 22nd of September they had accepted?
Have I? Okay, Chair,
Yes.
I do not communicate with the board, so I did not
Yes.
communicate with the board.
Yes, okay.
Yes.
But did you know whether anybody had communicated with the board to establish that they were happy with the price?
According to the board resolution, Chair, the board had never said like the price after it's finalized should go back to them. That statement that Ms. Hofmeyer is referring to where I said the board had approved, remember Asin's email to Jules when he responded and said, I'm gonna go to EXCO and the board, and after approval, I'll get back to you.
Yes.
So like that statement is referring to that part, not to the board.
Well, let's look at this letter, if we may, Ms. Mamela, because the first sentence says, your proposal for the purchase of the GPUs on behalf of Swissport was approved by the Board of SART and in accordance with the contract between SAA and Swissport.
Yeah.
The very next sentence says, kindly note that the approval, what approval is that?
Kindly note that the approval is based in the latest price review by yourselves.
Yes, let's just
Yes.
stop it. Kindly
Okay.
note that the approval. What approval are you referring to there?
I'm talking about the approval of the reviewed price, the latest price that they put on the table that was discussed with the acting CEO of SAT.
Yes.
Yeah.
So you discussed it with the acting CEO of SART before the 22nd of June?
Before the 22nd, I said like I discussed after the email that was coming from JM.
Yes.
Yes,
So you
between
had,
that.
you had his agreement by that stage?
I've had,
His agreement by that stage?
I'm sure I did.
And you don't accept that the approval you're referring to here is the approval of the board that you've been referring to in the previous sentence?
Okay, Chair, I just need to give clarity for your
Yes.
understanding.
Yes.
My understanding is that Asin Malorapiri, when he was writing that submission
Yes.
to the board, he
Yes.
was writing based on the proposal that was made by JM, and then his understanding, or maybe the knowledge now that Swissport and SAA had concluded a contract. Yeah, so him discussing and tabling this whole submission to the board involved that we were going to deal with the BE company of Swissport being JM. Yes.
Well, let me just, I think what Ms. Hofmeyer is trying to establish is this. In the first sentence of that letter dated 22 June 2016 addressed to Ms. Sokulu of JM Aviation, you say your proposal for the purchase of the GPUs on behalf of Swissport was approved by the board of SAAT. And then in the next sentence you say, kindly note that the approval, and that approval, as I read it, you must tell me if I'm wrong, that
Okay.
approval can only refer to the approval you talk about in the first sentence.
Yes.
That approval of the board was based on the latest price review by yourself.
Yes.
Now, my reading of what you are saying here suggests that you are saying that the board provided its approval being aware of the reviewed price. Is my understanding of what you are saying correct?
That was not my understanding, or maybe the interpretation when I ordered
That's not
this
what
letter.
you were conveying.
No, Chair.
What did you intend to convey when you said, kindly note that the approval is based on the latest price review by yourselves?
Okay, the approval, remember, Chair, the proposal by JM Aviation, let's go back to the date. It was 21 April 2016, which was before the board meeting, being the 15th of June 2016. So when Asin took the submission to the board to request them to dissolve these or to sell the GPUs, it was in that understanding that the GPUs will be sold to the BEE company of Swissport. Yes. So when we were negotiating in terms of the price, it was after the board had approved. So we did not go back to the board. No, do I have any maybe understanding if whether the acting CEO went back to the board, or maybe the board chair, or maybe the company secretary to confirm? Yes, that's why I said earlier on, the fact that the acting CEO signed the invoice shows that he actually agreed with the price.
But tell me what your understanding of that first sentence is. of that second sentence, I'm sorry. Because as I read it, it seems to imply that you are saying the board, when it granted its approval of the purchase, was aware of the latest price review by JM.
Okay, Chair, my understanding of this sentence is that I was trying to bind them to the latest price review. Remember, before Asin went to the board, they had proposed a different amount, right? And then after the board approval, we discussed with them, negotiated, and they went back a check, and then came back with a reviewed price with 20,000 rand more. So this was ensuring that when maybe we finalize or have the invoice, or we will have the correct reviewed price, they will not go back to the previous price on the proposal on the April 2016. Yeah.
So are you saying that you were not necessarily saying in this sentence that the board was aware of the reviewed price? You were saying the board has provided its approval, but you must know that when we talk about the approval, we talk about the latest review.
The review, yes, Chair.
And not the earlier price.
The price that they sent to the acting CEO before the board meeting, yes.
Yes. Okay, Ms. Hofmeyer, do you want to take it further?
Thank you, Chair. When the board met on the 15th of June, it was told that the GPUs would be sold at their current asset value, wasn't it?
Yes, Chair, it was told that they will be sold at the current asset value.
And now they were going to be sold at 248,000 per unit, which was not the current asset value, correct?
Chair, before I answer that, then this is the part where I find it relevant that I read that provision of the minutes that I kept on referring to.
Okay, is it a brief part?
It's just a brief part.
Yeah,
Chair.
okay, read it.
Yes.
Could you give us the page again, please?
Oh, okay. The page of the minutes from DD25, it's one, sorry.
25B?
A.
A. Okay.
Yes. Oh, it's page 193. First.
Yes.
Chair, can I, before I go there, can I read just for record purposes who was in attendance and present?
That's fine.
Yes. During this board meeting held 15 June 2016, present was Ms. Yake Kwinana, Non-Executive Director, Chairperson, Dr. J. Tambi, Non-Executive Director, Mr. M. Zwane, Executive Director, Acting Group CEO, Mr. D. Area, Chief Financial Officer. In attendance, there was Mr. M. Malola Piri, Acting Chief Executive Officer of SAD, Ms. P. Nanzi, SAA Interim Chief Financial Officer, Ms. U. Fikelepi, SAA GM Legal Risk and Compliance, Mr. S. Vilagaz, SAA Chief Audit Executive, Ms. M. Makake, Deputy Company Secretary, and apologies were from Ms. R. Ibuka. So I just want to read, Chair, now where it talks about the depreciation of the GPUs.
Yes.
Which made me understand that when Asin agreed to this,
Yeah.
it was because of this part of the minutes.
Yeah.
The submission proposed that SAT should... Oh, sorry, Chair.
What page are you reading?
Page 197.
197.
Yeah, second paragraph.
Yes.
The submission proposed that SAT should consider whether to recover the difference between the purchase value of the GPUs and the current asset value from SAA. The interim chief financial officer and the GM legal risk compliance indicated that SAT had been utilizing the GPUs whilst SAA was resolving its contractual issues with its ground handling service provider. Therefore, the reduction in value of the GPUs was due to the depreciation and was not a loss. This was during the board meeting, Chair, made by the Group CFO and the Group GM Legal Risk and Compliance. So to respond to Ms. Hofmeyer's question where it says, okay, then you decided to sell at 248 at the end.
You
So-
didn't say roof Hofmeyer, huh?
Did I
Oh,
say?
you said Miss Hofmeyer.
Ms. Hofmeyer, Chair.
Okay.
Yes.
Yes.
So, Chair, the amount there that was signed for in the invoice between myself and the acting CEO, Asin Malola Piri, my understanding then, right now that I'm reading, is that the reason why he agreed on that price instead of going back to what he had written on his submission is what was raised by Group CFO and GM Legal. And there was that understanding that the shortfall of the amount will be recovered from SAA, because remember the reason SAT bought these GPUs was to provide services to SAA. They did not buy them for the purposes that they were used for.
Ms. Mamela, the paragraph that you've drawn our attention to, which is the same paragraph that was in the extract of the minutes that we read into the record earlier,
Yeah.
is not comparing the current asset value of the GPUs and the sale price that was eventually agreed with JM Aviation. It is comparing the purchase price at which SART bought the GPUs the year before and the current asset value that had been communicated to the board by Mr. Piri.
Oh, did you make that calculation, Ms. Hofmeyer?
I'm saying the words say the submission proposed that SART should consider whether to recover the difference between the purchase value of the GPUs. That's the price that SART paid for them a year earlier, and the current asset value from SAA, which is the current asset value that was set out in Mr. Piri's submission to the board. That is the difference between the purchase price of about $782,000, which is reflected on the invoice, and the $648,000, which was the current asset value. This is a debate between the members of the board because we've seen the record of the proceedings. It's a debate between whether SART can recover from SAA because it's being forced to sell these units, the difference between the price it paid when it bought them and the price that SART was going to be selling them at the current asset value. I put it to you, Ms. Mamela, that this paragraph has absolutely nothing to do with the difference between the current asset value that went before the board and it agreed to sell these GPUs at, which was $648,000 odd, and the $248,000 a few weeks later that was agreed with JM Aviation.
The current
Do you have a
asset
response?
value, the current asset value, Chair, based on what? On the asset register that she rejected later, or what?
No, Ms. Mamela,
Well,
based on the submission of the CEO to the board of SAAT.
Do you know where the acting CEO got
Well,
that amount?
hang on, Ms. Mamela.
Yeah,
Ms. Hofmeyer has put something to you.
okay.
Just listen to her. I'm going to ask her to repeat and then just tell me what you say about what she's putting to you.
Ms. Mamela, the paragraph that you've read from the extracts of the minute refers to a comparison between the purchase price that SART paid for the GPUs and the current asset value, and whether that difference should be recovered by SART from SAA. It has nothing to do with the current asset value at the time that the board met and the later review price that you agreed with JM Aviation should be paid. Do you have a response to that?
Okay, my response, Chair, will be that even Ms. Hofmeyer does not know what the current asset value was at that time.
No. Do you agree or do you not agree with her proposition?
I don't agree, Chair.
Namely, that the paragraph you have read has nothing to do with the issue of the current value at the time of the assets to the price that they were going to be paid for by JM Aviation. That's the point she's making. She's saying her interest is on something else. You are referring her to a paragraph that deals with something else, not with what she's interested in.
For me, Chair, it is relevant. That paragraph, it is relevant, and you'll find out during re-examination.
Well, let's deal with it now. The submission proposed that SAT should consider whether to recover the difference between the purchase value of the GPUs and the current asset value from SAA. That seems to support what Ms. Hofmeyr says, that sentence. It talks about the purchase value of the GPUs and the current asset value from SAA.
Chair,
On the face of it, it seems to support what she is saying.
I was bringing your attention from the sentence where it said the interim chief financial officer
Yes.
and GM legal
Yes.
risk compliance indicated that SAD had been utilizing the GPUs whilst SAA was resolving its contractual issues with its ground handling service provider. Therefore, the reduction in value of the GPUs was due to the depreciation and was not a loss. So now I'm talking depreciation. That's why I was actually asking if Ms. Hofmeyr, I know maybe she hasn't done that or maybe she has proof. That's why I was asking if she has a proof like she had earlier this morning that there was that asset register which then we rejected because it didn't say who was it coming from. So I'm saying for us to actually agree that, okay, the current value of the GPUs at that time were the amount that the acting CEO had put there should be a document that supports that. So that's why I'm saying I do not agree to that because she's saying based on the submission by the acting CEO. Only the acting CEO can explain maybe when he gets a chance to come here and say, I came up with this amount based on this and that. If it's not here, it is not helping us, and it's not helping me, Chair, to give you a proper answer.
Okay, Ms. Hofmeyr?
Ms. Hofmeyr, Chair, I'm referring to myself. I see that Ms. Mbanjwa has her hand up.
Yes.
I don't know if she can...
Ms. Mbanjwa?
Thank you, Chair.
Yes.
I just want to point out something. The
Yes.
reason why there is a difficulty with that paragraph which appears in page 197 is because the questions that are put to Ms. Memela are based on a flawed premise. If there is going to be an attack on the review price to say the review price was below the current asset value, then we need to have certain inputs. And the inputs come from the asset register. The asset register must say, when were the GP units acquired? How are they depreciated? And what is the basis of the depreciation? And with that depreciation having been applied, then the current asset value is this amount. What Ms. Hofmeyr now is doing is taking a floating paragraph and is insinuating that this...
Remember that is Ms. Memela who referred to this paragraph.
Yes, the reason
Not
why
Ms.
Ms.
Hofmeyr.
Memela... Yes, Chair. The reason why there is a difficulty and why Ms. Memela is dealing with this is because it's the line of questioning, and I don't want to be critical. This is a complicated matter in the sense that firstly, it's an accounting asset register entry. It is for that reason why when Ms. Memela objected to the asset register, I supported that objection because I knew for a fact that if the asset register is not validated as an evidential document, then it means the inputs are going to be incorrect, or she's going to be cross-examined on inputs that are not really properly there. So what I suggest, Chair, is this, with your permission, and I'm not shielding Ms. Memela from asking questions. Can we deal with two things concerning this question of the price, whether the review price was the correct price? Because related to this question is another question that has been dealt with in a manner which is not satisfactory to us. Is the issue, but Chair saw it and tried to analyze to say, was Ms. Memela empowered to determine this price? So if we can be given a chance, maybe, I know not today, I want the matter to flow, to deal with those two aspects because they are directly related. First, who had the power to decide the price to dispose of the GPUs? Secondly, where is the genuine asset register And where are the inputs in the asset register? And what is the conclusion in the asset register insofar as what the actual current price was at the time the disposal was made? And lastly, if the review price, that is the subject of the emails, was below or equivalent or above that price.
No, that's fine. Ms. Hofmeyer will deal with what you have said, but if necessary, later on, you can bear it in mind later on at some stage, we can come back to it if necessary, but if we can deal with it now, it's fine.
Thank you, Chair. Ms. Mamela, do you accept that Mr. Piri made representations to the Board of SART in his submission identifying what the asset value was according to the register at SART?
According to this submission, Chair, signed by Mr. Malola Piri, yes.
And do you accept that the board made its decision to sell the asset value, to sell the SART GPUs at the asset value based on that submission from Mr. Piri?
Yes, Chairperson.
Thank you. What did you do to establish the book value of the GPUs before they were sold?
Chair, like I said earlier on this morning, if I remember correctly, I did say that as we were sitting there, we discussed with the JM representative and asked them how did they reach the conclusion to put that amount to their proposal. Can they actually go back and see? And at the same time, there was no way that we could have known for sure how much was the current value at that time based on the book value, because I said it was reliant on an outdated system being MEMIS. Everybody at SAT knows that system. The software has not been updated for years, even before I joined SAT. So everybody who checks the price there, Chair, in terms of the price catalog, they were told to not rely on that because it could be something, it could be maybe less or it could be more. So they should see if they can get something else somewhere else, you know. So and the asset register being managed and controlled by finance, so they're the ones who keep on updating. That's why when I raised this to Ms. Hofmeyer, like my discomfort in terms of the document that she presented to the commission, that it was the asset register. It had the date 2015, yet it was written by hand 2016.
But the short answer is you didn't do anything to establish the book value, is that correct?
We did not do anything to establish the book value.
Yeah.
Yeah,
Okay.
we relied on the negotiation on the table
Okay.
based on the initial
Yes.
proposal, yes.
So remember, I said I want us to go back to those crisp answers.
Yes, Chair.
Yeah, okay.
And what did you do to establish the fair market value?
Chair, I will try to give that crisp answer as much as I can.
Yes.
Remember, Chair, for me, or maybe for SCM, to give, to make sure, to confirm or to be comfortable that the fair market value or what is out there in the market, we should run a tender. In this regard, a tender was not ran. And remember, Chair, we cannot run a tender after the board had decided, because the board had decided based on the submission, based on the proposal made by Mr. Asin Malola Piri, and based on the contract between SAA and Swissport. So to answer Ms. Hofmeyer, it will be difficult to tell you what would have been a fair price, because...
No, I asked, what did you do to determine fair price?
Okay, there was nothing that could have been done at
Yes.
that time because the tender was not ran. So there's no way that you can determine that without running a tender.
And that's despite the fact that clause 8.2 of the agreement, which is the whole basis for the sale, required them to be sold either at book value or at fair market value. Is that right? You could do neither of those inquiries before you sold it.
Chairperson, the provision that Ms. Hofmeyer is referring to of the Swissport and SAA contract was concluded between it went to the board of SAT. You see, if maybe the owner of the GPUs, at that time when he actually was showing discomfort, or maybe he was uncomfortable with selling all 12, but he wanted to sell 7, maybe came to SCM, give the instruction or requisition request to go out on the market. and test the market in terms of what could be found here before it went to the board, I would have understood, because then I will have something that says there is a requisition form where, the owner of these GPUs had requested procurement to say, okay, let's test the market. Even if so, Chair, that if he had maybe asked us, maybe he was going to be told again that, okay, but this thing has already been decided on the Swissport SAA contract. Remember I said earlier, Chair, yes, Mr. Makaling raised the fact that he was not happy with selling all GPUs. And I said, Mr. Malola Pili, acting CEO, said, our hands are tied. The acting CEO said that our hands are tied because this thing has been agreed upon to do this by the high powers. There's absolutely nothing that he could have done. And for me to run or test the market to get the fair price would have been before the board.
Okay.
And after the instruction, Chair, because we don't just go out on a tender as we please.
Ms. Mamela, that letter of the 22nd of June that you wrote, were you requested to write that letter to JM Aviation?
These letters, Chair, we usually write after you've spoken to the person who has given you instruction. Hence I said, I'm sure after, as much as we don't have evidence, you don't have evidence as well, but after receiving the email from Ms. Sokulu, confirming that, okay, this now is the price.
Okay, remember, I think your answer is, I was not requested.
No, my answer is...
You were not requested
no, you
to
don't.
write the letter. That's the question, as I understood it.
We write the letter after the agreement.
You don't have to be requested by anybody.
You don't have to be requested by anybody.
Okay.
Once the approval is done.
Is that a short answer,
Yes.
Ms. Hoffman?
Thank you.
Okay.
The evidence of Mr. Cole of Swissport is that they were demanding repeatedly from JM Aviation that they get some letter from SAAT confirming that JM Aviation was SAAT's selected BEE partner for this bid and for this purchase. And what came back was this letter from you on the 22nd of June. Were you not requested to provide this letter by JM Aviation?
Chairperson, this is the letter either of award or when the final decision has been made. I would never write a letter based on the supplier requesting me to write it. That's why I said after they had written that email, of course, it was discussed with the acting CEO. And then once it is discussed with the acting CEO, I'm sure the understanding was to move forward and finalize and then give the letter of award. We have never given any letter of awards to people because they are asking for them. We give letter of awards when we know that, okay, the process internally has been done, which in this regard, it has gone through the board, finalized, approved, and we negotiated. So.
This is, Ms. Mbanjwa has sent me a note helpfully, just to say, could I give her the reference to where it is in Mr. Cole's affidavit? I don't suggest we have to go there for present purposes because Ms. Mamela has indicated she didn't receive a request. But for the record, it's at DD 25A. It's at page 267, and I'll just read it into the record before Ms. Mbanjwa makes her point. This is Mr. Cole's affidavit to the Commission. He says, in terms of SAAT's letter to JM Aviation dated 22 June 2016, included in Exhibit 18, I wish to stress that Swissport South Africa was neither consulted on the content of the letter, nor do we agree with the wording used therein. The letter was forwarded to Swissport South Africa in response to our repeated requests for evidence whether SAA or SAAT had officially appointed JM South Africa as a BBBE partner for the GPU transaction, and if so, whether the parties had reached agreement on the sale of the units. That's what I was putting to Ms. Mamela as the background to why Swissport had requested the letter, but I understand Ms. Mamela's evidence to be she was never told by JM Aviation that such a letter was required.
Yes, Ms. Mbanjwa?
Just very briefly, Chairperson.
Yes, come closer to the mic.
Yes, I would really beg that this be this procedure so that I don't have to object. Every time Ms. Hofmeyer refers to a document That document must first be put to Ms. Memela. And we must be given a chance to page to the document so that we can read the document and understand it for ourselves. It is not correct for her. That's why I'm making this strong objection. To put a statement of a certain Mr. Paul, which we haven't seen, and cross-examine or ask questions from Ms. Memela, it is very prejudicial, and we will be forced to object.
No. It's permissible for her for Ms. Hofmeyer to ask the question first and only go to a document on which the question is based later if necessary. Because sometimes the answer doesn't make it necessary to go to the document, but sometimes the answer makes it necessary. So it's a question of choice, a preference. She might start by referring to the document before asking the question, or ask the question first, and if the answer makes it necessary to go to the document, go to the document. But the answer might not make it necessary to go to the document.
In that
You understand?
case, yes, in that case,
Yes.
Chairperson, I will simply take comfort in the sense that you said, if I feel acute discomfort, I must
Yes,
make an
yes,
objection.
no, definitely,
As it
definitely,
is.
yeah.
Chair, just for the record, this is not a document that Ms. Memela has not seen. It's been in her
Yes.
bundle, and she considered it closely before her evidence on Friday for that half an hour.
Yes.
So there's no sense in which she hasn't seen Mr. Cole's affidavit prior to
Yes.
today.
Okay,
Chair, sorry,
yes,
just to give correction to Ms. Hofmeyer.
yeah.
This affidavit is
I'm sorry, am I hearing something that Ms. Memela is not saying? Why do I always hear something like roof before mayor?
Oh, Ms. Hofmeyer.
Ms. Hofmeyer.
Ms. Hofmeyer.
Yeah. Or you say
Okay.
Hofmeyer.
Hofmeyer, I mean,
Hofmeyer.
Chair, yeah.
Oh, no, it's Hofmeyer, okay. No, I was just wondering whether I'm hearing something that you are not saying or whether I'm hearing something you are saying.
Yeah,
she
she's
is
lucky,
Ms.
Chair.
Hofmeyer.
She's lucky, Chair, that my surname is quite straightforward and very simple.
Yes.
So that's why for her it's easy to say Memela.
Yes.
If she was using my maiden surname, we will be correcting every minute. Yes. So,
Yeah,
Chair,
no, I just wanted to make sure that the record doesn't reflect that you called her something
Okay.
by a name that is not hers.
Okay. Yeah.
Yeah, okay, all right.
All right. Chair, I confirm that for me, I did not read in detail the affidavit of Mr. Cole because I never received any 3.3. Yes, I even asked Ms. Hofmeyer if like this is for my attention, and she said like it's just for my ease of reference or maybe for information.
Okay,
Yes.
okay.
So that 30 minutes, there's no way that like with me applying my mind reading this document, I would have finished it at that time. I was going through some additional documents where I had received
Yes.
3.3 years. Chair.
In other words, you say you didn't understand the
I just
document to
bro-
be important.
Yes, I
for
just
any
browsed
reason.
through. I
Yeah,
did not
okay.
exactly.
No, that's fine, that's fine.
Thank you. Ms. Memela, I'd like to move off the GPUs now to the components tender. But in just summing it up, I'd like to put to you some of the observations from your evidence so that you can comment on them if you need to.
Okay.
Your evidence before this commission is that you did not take any steps to determine the fair market value of the GPUs. Is that correct?
Chair, I want to give you that crisp answer, but it does not allow me. This question does not allow me.
Well, you can start by giving the crisp answer and see
Yeah.
whether you want to elaborate, but just say
Okay.
yes or no, and
Yes, I did not test the market because the board had already decided.
yes, okay.
And you didn't check their book value either yourself?
The book value, like I said, Chair, we checked MEMIS, which was outdated. So we
Yes.
couldn't rely on that amount.
And you were concluding this agreement with JM Aviation for the sale price of the GPUs about a month and a bit after JM Aviation had paid the 2.5 million towards your Bedford View house. Is that correct?
I was, sorry?
You were finalizing the sale price of the GPUs with JM Aviation
Yes.
about a month and a number of weeks after they had paid 2.5 million towards your Bedford View house. Is that correct?
Chair, will I be problematic to...
Well, I think you probably want to say when they had paid that amount on
Yes.
behalf of your mother.
Yes.
I think that's the point you wanted
Yes,
to...
thank you, Chair.
Yeah, that's the point you wanted to make.
Thank you.
But in
because
terms of the time frame, she is correct, more or less a month.
the
or
amount
so.
was paid for the sale of the property.
Yes.
And towards the purchase of the intention to purchase the sale, the property from coverage.
Yeah.
Yes, so
Yeah.
this had nothing to do with the GPUs. And I wanted to ask Ms. Hofmeyer, see now I'm conscious because I kept on saying Hofmeyer, so Hofmeyer to direct me to the invoice of the GPUs. Yes.
Okay.
Because I just
Which invoice?
the invoice of the when site was
The sale from SART to
To
JM
GM,
Aviation,
yes,
not
yes.
the invoice from JM Aviation to Swissport.
now remember that has nothing to do with us.
It's at DD 25B at page 617.
Okay.
Ms. Mbonjwa, I see you raising your hand, but you feel apologetic about it. Okay?
I am, Chair.
Yes.
I just want to make a very quick conclusion.
Yeah.
There is going to be a problem with these conclusions that are put to the witness, because first, they are patently incorrect. We know there has been evidence here to say the 2.5 million was for the purchase of a property at Mpindwin. Then secondly, there is evidence here that the decision to dispose of the GPUs was from SAA, not even SAT, that is the main holding company. Yet the statement that comes from Ms. Hofmeyer is that Ms. Memela sold these things. If Ms. Hofmeyer can just kindly be very careful about the manner in which she words the things.
Yes, but you see, all those concerns belong to your re-examination.
I want.
Note them, and when you re-examine, you highlight what you believe is incorrect, whatever it is that you believe was incorrect, which Ms. Hofmeyer would have put to her.
Thank you.
Okay?
Ms. Mamela, did you share pricing information with the bidder about the prices that other bidders had bid for a tender while the tender was still open?
Oh, are we now? Okay,
Oh,
so
okay,
remember I
just
had
hang on.
requested. Yeah.
Wasn't there a question you had asked or proposition you had put to her,
Yes.
which she was still in the process of
No,
answering?
apologies, Chair, if that was the case. I'd understood. My last question was
Yeah.
that chronology.
Yes.
Was the sale price agreed with JM Aviation? A month and a bit after the
Yes.
purchase price
Yes.
had been directed to the Bedford View House? And I
Yes.
understood Ms. Mamela to say after your
Yeah.
introduction, yes, but insofar as it was related to a purchase for her mother's
Yes,
property.
yes.
That had concluded my questions on the
Yes.
GPU, and so I was moving to the components.
She said she wanted to look at an invoice,
Yes.
and
Oh,
I
right.
don't think
Yes.
she
Yes.
had made
Apologies.
the point she wanted to make on the
Yes.
invoice.
Yes,
Did you
Chair.
find the invoice?
I found the invoice, Chair.
Where do we find the invoice?
DD 25B at page 617.
Do I need to go to it?
You don't have to,
You
Chair. I
don't,
just
yeah,
wanted to
okay.
check the date
Okay,
and
all right.
confirm. Because Ms. Hofmeyer was referring to the letter that was sent to JM in terms of telling them that, okay, this has been approved. And then I see that the invoice was signed on the 11th of July, 2016, which I'm trying to now give clarity of like these two matters, like the payment of the property versus the Swiss port being finalized and stuff, have absolutely no link in between other than what is being painted out there in the public that maybe the amount that was paid for my mother's property could have been found from here. That's my assumption because I'm trying to understand why is this question asked between, like, I mean, okay, this was finalized between after the payment was made.
Okay.
And Chair, just to add one sentence now. I remember I promised that I will bring the offer to purchase between my mom and Mr. Nziku.
Yes.
And if I remember correctly, it was signed around November 2015. But because I was supposed to go to Eastern Cape today to get these documents and stuff, and I couldn't go. And I will provide that as soon as I get the chance, because I wanted to finalize with this and then make sure that, I provide that information. And then she's going to see that actually this was signed for 1 November 2015. The fact that like the payment for that purchase of that property took place in May is neither here nor there.
Okay. Ms. Hofmeyer.
Thank you, Chair. I'm indebted. I had forgotten about that page. If we can then move to the components tender.
And now we're moving to the bundle that has got her affidavit.
We are indeed.
Okay.
And
where
we'll
about?
pick it up. I need first actually to refer to an aspect of Ms. Sambo's evidence. So if I could, we don't have to go there, but the response is actually contained in Ms. Mamela's response to Ms. Sambo. Ms. Mamela, you'll recall Ms. Sambo's evidence was that you had provided her with a flash disk containing pricing information at a point while a certain tender was open. Do you recall that?
I recall the affidavit by Ms. Sambo, Chair.
And you have denied in response to her that you gave her that flash disk, correct?
Yes, Chair.
Are you aware that she found the flash disk and provided it to the Commission?
If you have sent it to me, if you have sent that information, then it means I have not received it. I did hear, Chair, from comments from, of course, my friends and family that apparently there was a flash disk that was shown that Ms. Sambo conveniently found it after I had said, for a person who was hell-bent to collect information about me to an extent where she went to Facebook and took my photos and stuff, and then the memory stick that she refers to gets lost. So for me, since I did not receive that, and maybe 3.3, then that says, okay, now, she has found it, I did not.
I think the brief answer is you never received it prior to your coming to give evidence, but you did become aware in the past few days or last week from people who told you that in the Commission, Ms. Sambo indicated that she had found it.
Yes.
Okay.
So your evidence today is still to deny that you gave her the flash disk, is that correct?
I deny giving her the flash disk.
Can we look at, apologies, continue.
Yes, finish your answer.
Okay, I deny giving her the flash disk because, first of all, Chair, there is no way that I will have those prices. The only time that maybe I will give her prices, or for instance, maybe that information in terms of me naively helping a black-owned woman and stuff, it will be just like prices that is out there on the market, not the price that is discussed by the CFST, because I do not sit in the CFST, as I earlier indicated in 2015.
Thank you. After we received the flash disk, which was on the night before Ms. Sambo began testifying, we managed to analyze it. Chair, I did indicate that there was going to be an affidavit from the relevant person in the Commission who did that analysis. It has been included in Ms. Mamela's bundle DD 25B at page 653.
Page 653.
Yes, page 653. Okay.
Chair, when was this made available here?
Well, Ms. Hofmeyer is going to indicate that, but it's a recent affidavit.
So you'll see that it was deposed to on the 5th of February 2020. You'll see that at page 657. Bundle DD 25B. It was deposed to on the 5th of February 2020.
Can you see that, Ms. Mamela? Are you on the right page?
on page
The annexure?
657.
657?
I'm getting you to the last page of the affidavit.
Yeah.
That's the 5th of February 2020. That was Wednesday last week. It was then included in your bundle prior to your evidence on Friday. So what Mr. Sifumba, who is the representative, the digital forensic investigator of the Commission, indicates in this affidavit is the circumstances in which it was obtained by the Commission. And then he goes over to indicate that he took certain steps to image the USB, and he extracted what is called the metadata from the file. You'll find that at page 656. And then his Annexure A, which is at 658, is a screenshot of the metadata, which indicates who the author of the document was on the, I didn't see that.
Well, maybe let's finish. Let's get to the question first, Ms. Mbandra, before we can interrupt. Let her finish. Or do you not have the page?
No, Chairperson, I'm not even objecting to the questions. Can I raise? It's a very fundamental objection.
Yeah.
The very nature of the evidence. I understand, having read the rules, that the chairperson has a full discretion on what evidence must be submitted. All I want to place before the chairperson is how seriously prejudicial this evidence is going to be. What has happened is a document that went where we do not know. And there is no chain of evidence to say that it left Ms. Memela and went directly to the person who testified, is now being presented here as a fact. So what we are asking is, because the Commission also had an expert to do this imaging. So what we are saying is, can we also have an expert? And then we will also have an expert on this document, because I, as an attorney, there is no way I'm even going to be able to cross-examine or to even re-examine or even do anything about this document, because I am presented now with this expert evidence of such a technical nature. This is one of those situations where I am begging the chairperson to afford us an opportunity, and we will ask our expert to sit with the expert of the Commission just to validate the veracity of whatever is there.
Yes, no. I understand what you're saying, but I think it's not something that, I think the question should be finalized. You will get an opportunity. I mean, Ms. Memela, I assume she's not a forensic investigator.
No,
I'm not, so I don't have the expertise. She will be able to say, I'm able to say something in response to this question, or I'm not able to say anything in response to the question. But you will get an opportunity, if you apply in terms of the rules, for leave to bring a witness, an expert, to deal with this expert's evidence. So that can be provided in due course. We should just hear what Ms. Hofmeyer, what questions she was putting to her. And she is free to say, I'm able to answer or I'm not able to answer. Okay. But you will get an opportunity, if you comply with the rules, to bring your expert. Yes, Ms. Hofmeyer.
Thank you. We were at DD 25B at page 658. And what Mr. Sifumba explains there is that this is a representation of what's called the metadata. It identifies the properties of the documents that are on the flash disk, the Excel spreadsheet. And what this revealed as metadata was that the author of the Excel spreadsheet was Leon Robertson, and that the Excel spreadsheet was last saved by, and the name there is Nonsasa Mamela. Do you see that?
I see that, Chair.
Do you nonetheless persist in your evidence that you would not have had access to any such information?
Chair, I am not prepared to answer that until I
you
know
get
for
advice.
sure, exactly, I know for sure where is this whole information, because I actually see that Mr. Leon Roberts also wrote an affidavit mentioning me, but I never was given the notice or 3.3 from Mr. Leon Roberts.
Yes,
Yes.
okay. So you're saying you are not prepared to say you stand by the answer you gave earlier on until you have got expert advice?
I'm saying I'm prepared to stand by the
You stand
answer
by the,
that I
yes.
gave to my statement
Earlier
with
on.
regard to
Yes.
Ms. Sambo's allegations that I had given her the memory stick
Yes.
with the prices
Okay,
for
that's
that tender.
That's fine,
Yes.
yeah. Okay.
And just to be clear, so that I know where we've left off, your evidence after that you would not have had access to this pricing information at all, you want to hold on confirming that until you've had...
I want to hold on
advice.
confirming to that, hence I said, Chair, the price that I could have, maybe, it will be priced from the market, just changing what is out there on the market, not the spreadsheet from the CFST where it is voted on and signed by the CFST.
Okay.
Yes.
Thank you.
Thank you. Let's move on then. I think to aid processors, we'll await any further application and we can take this evidence forward after that.
Yes,
Let's
that's
move
fine.
to your communications on the 14th of January 2016 with Ms. Sokulu.
So I think maybe just to conclude for now, the point you're making, you might want to put to Ms. Memela what you make of this
Indeed.
evidence, and then she will answer in whatever way, but she'll have an opportunity to consult an expert, and they can apply for leave to lead the evidence of a different expert. That would be fine.
Thank you,
As long
Chair.
as they comply with the rules. Okay, but I think to conclude,
Yes.
it's important
No,
to
it has
say
been left hanging.
what it is.
Absolutely.
Yeah.
I'm indebted, Chair. So we were focused on Annexure A, which is indicating the properties of the Excel spreadsheet.
Okay.
And what I'm indicating to you, Ms. Mamela, is that when our expert looked at the Excel spreadsheet, the information contained in its metadata was that you were the person who last saved that spreadsheet. Do you have a response to that?
I won't have the response, Chair, because it's something
Yes.
that was found from
No,
an
that-
expert
yes.
that, and I was not notified of it.
No, that's fine.
Yeah.
And just for the record, that on the same page is indicated as having been done on the 3rd of August 2015. Do you see that on page 658?
658.
So this is useful because if there are aspects that the expert needs to address, it will be
Yes,
whether in
yes.
any respect these facts recorded
Yes.
are wrong.
Yes.
And are you aware that the 3rd of August 2015 was 16 days before AAR submitted its tender on the 5-month components tender?
No, I'm not aware. Remember, I don't have the chronology.
Right.
Yeah, but what I remember, Chair, is that Ms. Sambo, who made these statements, was not party to the bid. And that it will be proven by her letter of aggrief, like where he sent an email to SAT complaining that, in fact, he said this to ENY, Ernst & Young forensic investigators, that he never bidded with AAR.
Yes.
She never gave them the authority to use her
Her
company
company,
and
yeah.
stuff. So that's where I'm actually not sure
Yeah.
that, when she said she got this, yet like in the other letters, she says no, she never gave them the authority to do this.
Okay, no, that's fine.
Thank you, Chair. I was going to move to the communications between Ms. Mamela and Ms. Sokulu on the
Yes.
14th of January 2016. Ms. Mamela, you'll find those in Ms. Sambo's affidavit. That is Exhibit DD 18. That should be next to you and available.
DD 18 page.
She will tell you the page just now.
Have you got DD 18? I don't think we've taken it out yet today.
Have you got an exhibit marked DD 18?
It's the evidence of Ms. Sambo.
It might not be there, huh?
Oh, DD 18 is that.
Okay.
And we'll pick it up at page 339.
Mayor, are you going to need to? Oh, okay, no, that's fine.
I'm actually realizing in the chronology it would be better to start at 367 of that exhibit, DD18. So if you'll just turn up 367, because there were two communications on the 14th of January.
Yes.
Let's start, Ms. Mamele, with the one at 637. Do you have that?
367.
Yes.
Yes, Chair, I'm here.
So that is the 14th of January 2016. Can you tell us who sends the email and to whom it is addressed? The one in the second half of the page.
Second half of the page, it's coming from Ms. Sokulu, 14th January 2016, to Nonzasa, my iCloud account.
And what does the subject read?
Hi, Kaz, so here is the latest
Sorry, just the subject first, if you don't mind.
Okay, forward South Africa draft proposal.
And then the contents of the email?
Hi, Kaz, so here is the latest proposal. Please let me know if it is acceptable.
And then there's a thanks.
And then there is a thanks.
And then
but
a
there is no, yeah.
Sorry, at 369, as I understand it, is the proposal that was attached. You've made the point that the only track changes on this proposal are those that are not from you. Is that correct?
Yes, Chair.
Yes. Now, on the 14th of January 2016, the bids were still coming in on the final 5-year components tender. Is that correct?
Yes, Chair.
They were due to be submitted on the 19th of January 2016, correct?
Yes.
And the allegation is that that communication with the bidder was in breach of the tender requirements. Do you have a response to that?
Was in breach of the tender requirement. Chair, if the person sits at the evaluation committee or bid evaluation committee, which is the CFST. So it is in conflict in that regard because you are sitting there, you know all the information, and you are the one who's going to vote, who's going to decide on this information. So the reason I say it's not, I'm not sure, maybe Ms. Hofmeyer is going to direct me on the legislation or maybe provision that says it's against the tender requirement for a person who does not sit in the bid evaluation committee to help or comment on certain proposals, especially with regard to what I had stated on my statement.
Yes. Ms. Mamele, as I understand it, your statement makes this very point. You say there's nothing untoward about the communication because you did not sit on any of the decision-making bodies. Is that correct?
That is correct, Chair.
And let's look at the second communication from that day. You'll find that at 339.
Before we go to that, 339, I wanted us to finish here, Chair, from
Yes.
367 and its attachment.
Yes, what would you like to say about the attachment?
It's a long attachment. I said on my statement, Chair, I'm sure whatever that Ms. Sokulu sent me this for was to confirm and check if the supplier development program or supplier development proposal is in order. As I had said, that the supplier development program was a new program at SAT. We had never given an opportunity to black-owned companies to join ventures with SAT. I'm the person who actually started that to empower black-owned suppliers in terms of these multinational suppliers. Now, from what Ms. Hofmeyer had referred to, which is the email from Ms. Sokulu to me, I see no evidence. Maybe she's still going to direct me to that. I see no evidence or email that is responding to Ms. Sokulu, and also on the comments, because it does show that this was a draft and there were track changes. There is nowhere where there are track changes where it says Advocate Memela
Yes,
commented.
but she hasn't asked questions about that. She wanted to move on to something, and you said you wanted to look something, and I thought it was relating to the last question she had asked.
Okay, Chair, maybe am I wrong, because
Yes.
this is the proposal, and I thought the one in 339 is talking to the JV. But
Okay.
yeah, but
No, that's fine.
these are two different documents.
Yeah, okay, thank you.
Given that you've drawn attention to it, I do have a follow-up question. You said you're sure that Ms. Sokulu was sending it to you to look at the supplier development aspects, correct?
I think so, yes, Chair.
You think so? So did you have a conversation with her about it?
Did I?
Have a conversation with her about it when she told you what she wanted you to look at was supplier development?
No, I don't remember having a conversation in writing, Chair. I may have had a conversation verbally, maybe saying, I think it actually covers the supplier development. These are the communications that I've received from so many BEE companies, Chair. And as I mentioned in my statement, that I even had an MOU from Guane Capital being the BEE company of Air France, which I signed for. So, I mean, those are the people that, it was the first time for the door to be open for them to actually deal or maybe participate in these big companies and with these big multinational international companies. You know, so it was my duty in terms of the job description and also in terms of the, I don't know if Ms. Hofmeyer, I've sent you that, but there is an enterprise development supplier program that was done in 2014 that actually gives us that obligation to promote the joint venture relationship between multinational company and local companies.
So just let me get your evidence clear. You did have a conversation with her in which you responded to this email on the 14th of January telling her that you thought the supplier development aspect of the bid looked okay. Is that your evidence?
Okay, I'm saying, Chair, I said, I don't remember if there is any written response from me, but I do know that when I receive these, like I receive from any other mini supplier, BEE suppliers, I respond either by phone and say, okay, I think this is in line with what is required.
Yes, but she's saying, do you recall whether you did have a conversation with her telephonically or in a meeting with her?
I don't recall, Chair.
You don't recall?
I don't recall.
Yeah, okay.
So you have no other basis for thinking that she was just asking about supplier development unless you'd had a conversation with her, correct?
I have no, sorry?
Basis for concluding that she was only interested in your input on supplier development unless you'd had a conversation with her.
The basis will be that, Chair, I would not have the information to discuss any other information of the tender other than supplier development with her, because I don't sit in the evaluation committee, being the CFST at SAT. Yes, and the other basis is the fact that there is no way where I had helped them for them to win. I corrected Ms. Hofmeyer on Friday when she referred to Lufthansa as being number 3 bidder. And I said Lufthansa was number 1 bidder. So that was the winning bidder in terms of the scoring points.
And Ms. Memela, do you recall considering the proposal that was attached to that email when you received it?
Considering it?
Looking at it, reviewing it?
I don't recall, Chair. I think it was, when was it? It was in 2016, so I don't recall what happened. And Chair, the reason why I would say I don't recall as well is that the reason why Ms. Sambo has these documents, it was again for the same basis that Ms. Sokulu sent me the documentation. It was to assist her. Remember in 2016, in the final 5-year tender, Ms. Sambo, what she did not mention here in the commission when she was here, or maybe in her affidavit, she did not bid in that tender because she did not have any partner to bid with. You understand? So, and the reason why I gave her, because she was frustrated, she wanted to see if she can actually approach other multinational companies, because remember, in the 5 months period contract or tender, they had not seen eye to eye with
Yes.
AR, exactly. So,
Yes.
of course,
I
they
think she
couldn't.
mentioned that.
Yes, so
Yeah.
she couldn't bid with them.
Yes.
So the reason I gave her this was me saying, okay, remember, you have been complaining about this. I'm
Okay,
sure.
Ms.
Yeah.
Mamela, okay, the question
I
is
was
not
giving
about that.
the
yeah,
evidence
it's not
for you
about that.
to understand the
Yeah,
background,
I know.
yes.
I
Okay.
understand, Ms. Hofmeyer.
Let's go to the other email on the 14th of January. You'll find that at 339 of the same bundle, Exhibit DD18.
Page 339.
Yes, just tell us who the email is from and to.
The email is from Ms. Kosiso Kuluche.
And it's to.
It's to Nontsasa Memela on the same date as the proposal was
And the
sent.
subject this time.
The subject this time is joint venture draft agreement.
And what does Ms. Sakulu say in the first 3 lines?
Hi cousin, this is the first draft of JV so far. Jules did a quick review and noticed the following. And then she states 1, agreed participation, JM 5%, AR 95%, 6, participation interest, JM 5%. Do you want me to read the whole thing?
Yes, that's fine.
Okay. As per the collaboration agreement, JM is to receive 5% of any amounts received by AR from SAD. This is linked to revenue, not profits. For example, if SAD remits 100,000 US dollars to AR, then JM is to receive 5,000 US dollars. The way the participation interest clause is written states that JM will receive 5% of the profits. This is not correct. We need to determine what will 5% of revenue equate to as a percentage ownership of the joint venture for JM. Please let me know if there is anything else we might have overlooked.
Thank you. Why would a bidder on a components tender that's still not closed be engaging with you as the head of procurement about the details of their JV agreement with their bidding partner?
Okay, Chair, as I said, it's just that you did not give me that opportunity. Maybe you were worried that I would be my old self and take long. I wanted to give the full background.
Well, if you can,
It will take me about 2 to 3 minutes, I promise.
that's quite long.
Or 1.5.
Okay, all
Okay,
right.
Chair. Chair, as I had mentioned on Friday, SAD had always used the international multinational companies to supply spares and everything else. And there has never been any participation between local companies and maybe joining ventures with international companies. And then we had the likes of Ms. Sambo, who had been knocking on SAD door from 2012. I'm sure you can see the evidence where she started bidding with AR. And from that moment, she had not had the JV that was protecting her from, in case AR runs away like they did, you know. And during that time when she actually introduced herself to me, the first question I asked her, do you have a JV? With these guys, because like remember, you will not have a formal claim or a legitimate claim from them if you don't have a JV. So for me, I was fully involved in terms of discussing the JVs and supply development program and others. It was MOU between multinational company and versus local company like Kwane Capital with Air France. They had an MOU. So to answer Ms. Hofmeyer's question, it's that the reason why they had like maybe sent it to me was also to check if they are doing it, like because they were using their own lawyer, they were not using me, but maybe they just wanted me to check if they are not negotiating to their disadvantage, like Ms. Sambo had done. For the first time during her affidavit, I saw that, okay, she had a contract with AR, which she never disclosed to me, because I would have told her there and then that that is not going to work.
Okay, Ms.
Yes,
Mamela.
okay, it's all.
Okay.
So, Ms. Mamela, they were coming to you for legal advice.
No, they were not coming to me for legal advice. They were coming to me like for a JV and having the relationship with the multinational company, because like remember that JV will be the basis of what will be maybe accepted by SAT in terms of like understanding that, okay, there was no fronting, or maybe there was no, they just like use these black people because they were available and stuff. So it will be something that will go for the remainder of the contract.
So it was to understand what would be acceptable to SAT.
It was to, remember the JV is an independent document from SAT.
Yes, that's why I'm interested
Yes.
in why they are sending it to the head
the-
of procurement.
Yes, Ms. Hofmeyer's interest is why would a bidder who is preparing their bid to the company where you are HOD of procurement
Yes.
be sending you their draft proposals and asking for your assistance?
I would think, Chair, they wanted to hear my view if they are not negotiating to their disadvantage. I mean, even Kwane Capital and Air France, during the 5-month tender, they sent me the MOU between themselves, and it was talking, now it was not as detailed as this, but it was talking about the percentage that Kwane Capital is entitled to.
But that would just be strange, would it not be? Because isn't the position with regard to tenders that each bidder is supposed to prepare its bid to the best of its ability and put it in without sharing it with another potential bidder for the same thing? Put it in. The bidders shouldn't know each other's bids, proposals, and the employer, the SAT in this case, would then, on a certain day, open them, look at them, and see which one is the best. And in the process, as they prepare their bids, they might disadvantage them. They might put in something that will count against them. They might put something that will not count against them, but they have got to put their bid as they prepare them.
This JV, Chair, was not part of the bid. So as I'm trying to correct that part where you're saying like they should, the only one that was part of the bid is this proposal. And I will go back to...
Yes, but remember that part of Ms. Hofmeyer's question is why were they giving you all of these documents, asking you for assistance from you when one, they were one of the bidders, two, the bid had not been closed?
Chair, in my reading of the email, I don't see anywhere where they ask for my assistance other than they said, please let me know if there's anything else we might have overlooked.
Yes.
Well, that is asking for assistance, isn't it?
Okay, and also there is no email that shows that I had gone back to them and given.
No, Ms. Hofmeyer is not there yet.
Okay.
She is still simply at the point where we know
Yeah,
they are sending you documents, including a proposal,
okay,
and saying, tell us if this is fine.
yes, Chair.
So she is asking the question, why would a bidder be asking the head of procurement of the company to which they are going to submit a bid to first check whether their proposal is acceptable? Why are they not simply putting in their bid after preparing their bid to the best of their ability and then be judged on that?
For the proposal, Chair, that you're referring to, that's why I'm saying I think they were asking me if their supply development is in line with what is required, because as I said, that was a new program at that time. So whatever that was put on the table, it was new and we're working together. And since I was not sitting at the evaluation team, I was the one who they could approach.
Ms. Hofmeyer?
Thank you, Chair. Ms. Mamela, the one thing we haven't noticed yet for the record is what email address of yours these requests for assistance were sent to. Could you read into the record what email address they were sent to?
Chair, if I read my email address, it will be known to the public and I will
Oh,
receive,
apologies.
I will receive
Okay. No, no,
insults
no.
and whatever.
No,
So-
I can ask it
you're right.
differently, thank you.
Yes,
They
yes.
were not sent to your SAAT email address, were they?
They were not sent to my SAAT email address, Chair. They were sent to my private email. And I did mention on my statement that others would send me SMSs on my private phone and then I would respond to that. As I had been also communicating with Ms. Sambo, you'll notice that I had communicated with her on the private side. You know, not because like we're running away from anything, but I took that to me that I am actually guiding them. To add that, I won't take long, there is somewhere where it talks about the joint venture or shareholders agreement or consortium on that 5 months contract or 5 months tender where there were other black-owned companies that I saw from Mr. Human's file, that there was a consortium, also it is in my file, there was a consortium where it was listing certain people and Mr. Human in his affidavit, he said, I agreed to meet with the BEE companies like that, we're forming that shareholders agreement, just to prove that I had not only communicated with maybe JM or maybe they were the ones who actually communicated with me. I'm actually trying to prove that there were other people who were reaching me on the side to see. And then I remember on the consortium one, we did not agree because I told them that you cannot just come with something that has already been done and then when this thing is ran by SAT.
So did you use your iCloud email address when you were providing guidance and your formal SAAT email address when it was formal communications with entities?
When it was formal, okay.
You see, let me...
She is asking, when did you use your private email address and when did you use your official email address in communicating with these companies, PE companies?
Okay, Chair, it depended. If I was at work, some would communicate to me via my work email. But because I had a problem with my connection at home, then because I would connect only via my private email. So if I'm at home and people want to talk to me, they would use my iCloud account. Yes, Chair.
Right, thank you for that. I'd like to take you to, before I do that, Ms. Mamela, should we not take it as in any sense an indication that something was happening alongside this bidding process, that your iCloud or private email was being used? I understand your evidence to be you would regularly use that in your interactions with bidders.
I said I would use it when I'm at home, when they can't reach me on my work email, then I would let them use my private email account.
So were you at home at 4 o'clock on the afternoon of the 14th of January 2016? Because that's when the email came from Ms. Sokulu to you.
I wouldn't remember where I was.
So, but do you remember specifically saying, use my iCloud email address because I'm not at work?
Remember, Chair, if for the fact that Ms. Sokulu sent that email at 4 p.m. does not mean I have read it at 4 p.m. It might happen that, okay, maybe I read it later or maybe I was, so I can't really answer that. I was at home at that time.
No,
Did they, was the position that during normal business hours, if they wanted to send you an email, they would use your official
The web
email?
email, yes, Chair.
But after hours, they would use your home, your personal private email address?
Yes, because...
Is that the position?
Yeah, that's the position, Chair.
Okay.
Yes.
Ms. Mamela, your previous evidence this morning, I think it was that as the HOD of supply chain management, your role was to run tenders and to make sure they adhered to processes. Is that your evidence before this commission?
What I had said also on Friday, Chair, if I must repeat, is that the CFST or maybe the Bid Evaluation Committee, they bring the recommendation to me without any other administrative documentation to check if it is flowing, and we will be able to talk to it when we go to EXCO, to BAC, and then when the CO goes to the board. So she, like Ms. Hofmeyer, asked me if I'm saying I signed as the EXCO member, and I corrected and I said, no, I sign as HOD SCM, as I'm signing in support of the bid evaluation committee, based on what they had put on the table to me.
Yes, and I understood your evidence to be you are one of the checks that the process has been properly followed. Is that correct?
Remember, the duty to check the process if it's properly followed and stuff is partly mine, but mainly by the BAC. As I said, that the BAC will check all the relevant legislation on Friday. I said they check all the relevant legislation and whatever that they have gone through CFST and see if everything was checked.
So your answer is you check parts of it?
For instance, Chair, I had said on Friday, there is a recommendation that is made by the project manager. In this regard, it was Leon Roberts. And then for the 2016, and when he brings the recommendation with the, what do you call this, summary of what they had discussed there and evaluated and whatever, and then come with the proposal to say, this is the highest scoring bidder. In this regard, the initial highest scoring bidder was Lufthansa.
Yes, but the answer, your answer to Ms. Hofmeyer, is it that, yes, you are part of the people who check?
Yes.
You are not the only one, but you are part of the people who check.
Yes, but...
That's right.
Yes, Chair.
Yeah, that's
Yes.
fine.
Yeah.
Were you aware that it was prohibited under this bid for there to be any communication between a bidder and somebody other than the project manager at SART?
I am aware of that.
Great, let's go to it if we may.
Yeah.
It's in Human's bundle. You'll find it at DD 22E, and it's at page 2052.
DD?
DD 22E at page 2052.
Did you say DD 22E?
Correct, yes.
Of Ms.
Mr. Human,
Human?
and then you'll turn up page 2052.
2052, okay.
Chair, I've picked it up in the middle of the document just for records purposes. The document begins at 2043, and that is the request for bid on the final components tender that was eventually awarded for 5 years to the joint venture of JM Aviation and AAR. And Ms. Mameli, your evidence was that you were aware of the provision in this tender that prohibited communications, and I'd like to take you to the relevant clause. It's clause 1.6 at page 2052.
Have you got it?
1.6, communication surrounding the RFP, yes, Chair.
Yeah.
Yes. So 1.6.1 there records, all queries or information relating to this document or surrounding the bid must be addressed to the project manager as stipulated on page 1 of this RFB in writing. Clause 1.6.2 provides any queries addressed to individuals other than as stipulated, whether verbal, telephonic, and written, or in any other form, will eliminate the bidder from this process. Do you see that?
I see that.
Do you accept that JM Aviation's communications with you on the 14th of January meant that they should have been eliminated from this process?
I don't agree, Chair.
Why is that?
Okay, the people, or maybe the individuals that are referred to in this tender, Chair, are the individuals that are sitting at the bid evaluation committee. The people that sit and go through this tender, putting the specification in this tender, the specification committee which form part of the CFST. So those are the people that are not supposed to talk or maybe communicate with the bidder. And I even made an example for the bid of 2014.
Before you make the example,
Okay.
what is the basis for your evidence that the individuals referred to in clause 1.6.2 are the specific individuals you are talking about?
My basis, Chair, is the fact that the people who come up with the specification of the tender are those people that sit at the CFST, who know exactly what is required by
Okay.
SAT. Yes.
Okay, all
Yes.
right. Let's do it this way. Is there anything in this document where clause 1.6.2 appears? Is there anything on any page of that document which makes you say the reference to individuals in that clause is a reference to the people who deal with specifications?
In this
Or there's
clause.
nothing? In this
In this
document?
clause, it is not here, Chair.
Yeah, in the
And
document as a whole?
In the document as a whole, I have not gone through the document as a
Yes,
whole.
but you are not
but-
basing what you are saying on the document.
But I know that, Chair, before this document is put through, is put together, there is a CFST team that is responsible for specification and everything that is going to be part of this tender. And this is usually referred to them because they know more about the tender information that they are voting for, evaluating or adjudicating. So I wanted to add, Chair.
Yes.
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 The reason why I say this is referring to the people that sit at the CFST.
Yeah.
Remember, there was a point where Mr. Human referred in his affidavit that during the bid of 2014, the board was in discussion with AR at that time. Remember, the bidder also was AR, but the board was discussing with them in terms of the MOU and all that.
I'm sorry, Ms. Memela, we might have to come back to
To that,
what you are
okay.
saying. But let me just draw your attention to this. Clause 1.6.2 is clear. It says any queries addressed to individuals other than as stipulated. So it means it's very specific that if you are going to communicate, these are the only people you must communicate with. And your answer seems to suggest that this clause, you understood this clause not to restrict communication to individuals, to certain individuals.
Yes, Chair, because I think it will be referring to individuals that are directly making the voting and the evaluation.
Yes, but Ms. Hofmeyer, do you know where the as stipulated refers
Yes.
to? Let's go
I
there.
can give you that.
Yeah.
It's at 2043. Yes, because what happens on 2043 is the project manager is identified. You'll see it says as stipulated on page 1. Let's just read it for the
Sorry.
benefit.
Sorry, Chair.
2043,
Yes, is page 1 of the RFB. If
Okay.
you look at the bottom, it's page 1 of 44, right? If I can just give the assistance, what 1.6.1 is saying is all queries or information relating to this document or surrounding the bid must be addressed to the project manager as stipulated on page 1 of this RFB. So then you go to page 1 of the RFB.
I'm sorry, Ms.
Apologies.
Hofmeyer, I can't see where you are reading.
I
I'm
do
at
apologize.
2043.
Okay, so I was just giving the context for why I take you to that page,
Yeah,
right?
okay.
What we need to be looking at is 20.2052, which is where the relevant clause is, right?
Yeah.
And I'm just saying what the clause provides is in 161. All queries or information relating to this document or surrounding the bid must be addressed to the project manager as stipulated on page
Page
1
one.
of this RFB.
Yes,
That's why I
yes.
take you back to 2043 because that is
Yes.
page 1 of the bid. And
Yes.
you'll see in that first block,
Yes.
RFB particulars,
Yes.
you'll see on the left-hand side there's a column saying bid queries. And across from bid queries in the second column is project managers. So they are the project managers stipulated on page 1 of the RFB. They are Mr. Leon Robertson and Ms. Evelyn Fallett.
Yes.
So that is the cross-reference, I think, Chair, that you were looking for.
Yes, no, that's the one I was looking for.
Yes.
You
And then-
see,
Apologies, Chair.
yes. You see, the way I read clause 1.6.2, Ms. Memela,
Yes, Chair.
is that it must be read with clause 1.6.1 and page 1 of the document,
Yes, Chair. I saw
and that it prohibits communication between a bidder and anybody within SART other than the people stipulated in terms of clause 1.6.1 and page 1.
Okay, Chair.
Yeah, that's how
Okay.
I understand it.
That's how, yes.
Yes.
Chair, I will explain now to you that this is a document, as I said, with the specification and the document that is compiled by the CFST, right? And the document is compiled for the bidders. This document is not given to me. As you can see that it's not assigned to me or maybe where I sign it off, right? So I'm not trying to defend the fact that maybe I may have not seen this, the clause that is referred to, that they should not communicate with anyone. Maybe they were aware, I was not aware, and I even said to my statement, even Mr. Nico Bezedinwood, being the acting group CEO of SAA at that time, and with Mr. Barry Person, they met with Air France. Air France went there to discuss the bid of the tender during the bid process. And when I tried to check if, after I found out, because Nisha came and notified me, remember Nisha was the senior manager, SCM at that time. She came and notified me because she was called in that meeting and said, Nonzasa, these Air France people went to discuss with Mr. Nico Bezedinwood and Barry Person, and what they were discussing there is exactly what the bidder has bidded on the tender. So the reason why I could not, I could not disqualify them from the tender after getting that information, after sitting with Mr. Masimba Dao, who was the CPO of SAA at that time. We sat down with legal, and this was discussed, and they said this, but this, for instance, Mr. Nico Bezedinwood and Mr. Barry Person does not have it. Only the supplier has it, which is the reason why when I sent an email to the supplier asking them, they must give me valid reason why I should not disqualify them. And unfortunately, that has not been, Open Water knows about it, but the team of the commission did not bring that email. Yeah, but I'm just going back there, Chair, that the fact that this is written here, it does not necessarily mean that like the people who are not sitting there understand it, because it's not given to us before it's sent to the bidders.
Okay, so
Yeah.
your answer is you were not aware of this prohibition.
Yes.
Your understanding was that there was nothing wrong with the communications with the bidder. Is that what you're saying?
The understanding is that there was nothing wrong because I don't sit in the evaluation committee. The only people that are not allowed to talk to the bidders, because they have all the information, they're sitting there, are the people in the CFST, the bid evaluation committee, Chair.
Ms. Mamela, the challenge I think that your understanding presents, and I want to put it to you in fairness, is that no one at SART other than you knew that JM Aviation was corresponding with you on the 14th of January to get input on their bid proposal. Is that correct?
Yes, there was no one.
So only you know that a bidder is currently asking for your input on their bid proposal, correct?
Yes.
And then there is a provision of the RFB that says they cannot communicate with anyone other than the project manager, and if they do, they will be eliminated from the bid. You've indicated that you were not aware of that provision at the time, correct?
I was not aware of that provision.
If you had been aware, would you have raised a flag when you got the submission from CFST and said, I see that you've evaluated JM Aviation and AAR, but they should be eliminated from this bid because they've breached clause 1.6 of the RFB?
For instance, Chair, if there was a certain policy that is known to all the executives, for instance, including even Mr. Nico Bezedinwood and Mr. Barry Person at that time, which notifies the management or maybe executive that, okay, should you receive any communication from the bidder, even if it has nothing to do with the requirements of the tender, it's just about supply development, yes, then I would have notified Leon, the project manager. And just to add there, Chair, okay, this is the part where you said you will allow me to add with regards to open water report.
I may just have a follow-up question.
I said later.
Later, Chair,
You
yeah.
must just not to forget, make
Okay.
make a note.
Okay.
Yeah.
Ms.
Okay.
Mamela, your evidence a moment ago was that all that you were sent was something in relation to supplier development by JM Aviation, correct?
That is my vision, Chair.
Yes, except that what you were sent was the entire bid proposal. Is that not correct?
The entire bid proposal, I said, Chair, the reason why, I just wanted to note this so that I don't forget later.
Yeah, noted.
The part that
Noted,
I
yeah.
want to raise at the end with regard to bidders communicating
Yeah,
with people
noted,
at site.
yeah.
Okay, Chair.
Thank you,
Yes.
Ms. Mamela.
Okay.
You confirm that you were sent the entire proposal.
I confirm that this is an entire proposal, but
Yes.
I said earlier on, Chair, that it probably, because she was asking me what could have been the reason for them to send. I said probably because they knew that I did not have the information for the tender, as I don't sit in the bid evaluation committee. So it was for me to check the supply development part.
How would
And
they-
the reason why it was this, I did not see anything wrong with me sharing with Ms. Sambo. It was to help guide her when she approaches other bidders, other suppliers to become their joint partner.
Ms. Mamela, how would JM Aviation know that you weren't sitting on the bidder evaluation committee?
How will they know?
Yes.
No, I mean, we get the briefing sometimes, they know exactly that I don't sit in the CFST.
You
All the
briefed
bidders
them.
know that. No, I don't brief them. All the bidders know that I don't sit in the bid education committee.
I'm just trying to understand how they're given that information.
How are they given that information? Because, I mean, the HOD-CM has never sit in the bid adjudication committee, ever.
Yeah, but that's knowledge internal to SART. How do external parties to SART know who sits at the bid evaluation committee?
Chair, I don't know if you remember, on Friday, I mentioned that one of the JM directors, Mr. Jules Eyre, has been the SART supplier since 1992. They get to know about this internal information, what happens where, who sits
On an
at the
official
board.
basis,
No, not on an official basis sometimes. Sometimes like just through
do they get to
discussions.
know something they're not supposed to know?
Not that like it's something that is hidden, but like it has never occurred that an HOD or maybe a person at the executive level will sit at the CFST. At the CFST, yeah.
That's internal.
Yeah.
The question is, if SAT did not officially inform the bidders who would sit on the CFST,
Yes.
how would they know?
Okay. As I said, Chair, when I was talking about that proposal, that the only reason I know that they would send me that proposal to check is for supply development, because I was open to them about supply development. I was fully involved about supply development because it gave points back to SAT. So it was not about me saying they
Yes,
knew.
but that
Yeah.
doesn't answer the question. You remember, Ms. Hofmeyer is saying, here are
Yeah.
people, here is a bidder communicating with you
Yes.
at a time when they are preparing to submit their bid. And your answer is there was nothing wrong with that because you did not sit on the CFST.
Yes, Chair.
So her question is, how would they have known that?
Okay, Chair. I said I would assume that since Mr. Jules had been at the database of SAT since 1992, would have maybe known that information, because it's not something that is critical to hide or whatever. Sometimes, like, I mean, during the tender process, there is a briefing session where the bidders would know who is part of the evaluation. During that meeting where all the bidders are there, all the CFST team are there.
Well, I don't know, but if I was told that the identity of the members of the CFST was not supposed to be disclosed to bidders, I would understand that. it may be that at such there was nothing wrong with that because it was believed that that would not compromise them in any way. But you are not saying, or are you saying that officially the identities of members of the CFST were made known to the bidders at some stage or another?
Not really, Chair.
Not officially?
Not officially. That's why I was saying
Yes.
sometimes during the briefing process, they would meet all the CFST members because they are there to answer their question in terms of the specification of the tender. So they will see that, okay, maybe Ms. Memela is not there, the CEO is not there, or maybe all the GMs are not there. The same as Mr. Nico President Hood will not sit there. So when they meet, when they ask, for instance, if France asked to meet Mr. Nico President Hood in Bariphasin, the understanding is that they will find out somehow that these guys are not part of the CFST or bid evaluation committee.
Okay.
Ms. Mamela, the other possibility is not that they found out, but that they're trying their luck, isn't it?
Okay, the other possibility is that like they will...
So they don't know who sits on the CFST and who doesn't, but they're communicating with somebody hoping that they'll get a response.
Trying their luck, I don't know. I wouldn't agree. That's your vision. Sure.
And just to finalize, because I didn't think I had a crisp answer to the question, if you had been aware of clause 1.6 of the RFB at the time, would you have raised the flag before, once you got the CFST's recommendation and said, hang on, we can't possibly award this to JM Aviation and AAR because they were communicating with me during the bid?
Okay, Chair, if I had known this document, or as I said, if there was a formal document signed somewhere that says, okay, executives be aware of this, should anybody communicate with you, please don't communicate back, or just notify the CFST, then we'll disqualify them. Then I would have raised a hand and called Leon and said, okay, Leon, these are people are communicating with me. Leon knows that I did not hide anything from him. I did tell him who was talking to me in terms of supply development, and he did not have a problem with that. AJ Walters, like they had out their own BE company, and they were talking to me about that, like for guidance in terms of supply development.
Yes, except Ms. Mamela, your evidence a moment ago was no one else other than you at the time knew that they'd communicated with you on the 14th of January, 2016.
Okay,
I think she's making a different point.
yes, I was making a
She's making a point that JM was not the only
only
one.
the-
Yes,
communicating
no,
with her. Yes.
apologies, Chair. And I picked up on the point that she said she had been communicating with Mr. Robertson about the fact that there had been these other engagements on supplier development. I guess in fairness, I should be clear. I just want to be certain that I understand your evidence in relation to the JM Aviation communications on the 14th of January. No one other than you knew that they had had those communications with you prior to the bid closing on the 19th of January, correct?
My recollection is that, Chair, that they had communicated with me at JM Aviation. So, of course, I did not say I have told Leon every communication. I said I had shared with Leon some of the communication with
Thank
some
you.
of the BE. Just to add there, of course, Chair, like it will be added in the re-examination, but like this information was given to Ms. Sambo in that notion that I'm helping a black-owned company to have an understanding of what is required in terms of supply development. I heard her talking about NIP obligation, and I could tell even like from Mr. Skalk Human that they both don't understand the difference between the NIP obligation and the supply development. They don't understand that the NIP obligation is actually managed and controlled by the DTI, and then supply development gives SAD that advantage to control what is happening within the contract, within everything that has been agreed upon. That way we are getting back the points for BE status, you know.
We'll come to NIP in a moment, but just before we go there, were you aware that it was a requirement of this bid that a NIP obligation be undertaken?
Remember, Ms. Hofmeyer, you cannot apply both, Chairperson. You cannot apply both NIP obligation and supply development. The only requirement that the DTI makes is that you must make sure whatever that you decide to apply is stated in the tender from this tender from the beginning, so that the suppliers are aware exactly what they are putting themselves in. So yes, in terms of the amount, it fell within the NIP obligation, but like because we introduced the supply development in terms of the program, NIP obligation fell away.
Ms. Mamela, my question was, are you aware that the request for bid made the NIP obligation applicable to this tender?
Made the NIP, so are you saying the NIP obligation was the requirement of the tender?
Indeed. Would you like me to take you to the
Please.
page where it was the requirement?
Yeah.
Let's go to that. It's in the same bundle, DD22E, at page 2083.
2083.
Yes.
Are you there, Ms. Mamela?
I'm here, Chair.
My question was, were you aware that it was a requirement of this RFB that the NIP obligation be undertaken by bidders?
I think you wanted to tell her to identify the part of the page.
Indeed.
That is, I think that's 1.0, is it not?
Indeed. So it begins by explaining to the bidders what the pillars of the NIP program are. It requires them over the page at 2084 at clause 3.1 to submit SBD5 together with the bid. That is a document relating to the NIP obligation. And then over the page at 2085 at clause 4, it deals with the process to satisfy the NIP obligation. Once, at 4.1 it reads, once the successful bidder or contractor has made contact with and furnished the DTI with the information required, the following steps will be followed. And then it indicates how satisfaction of the NIP obligation, which the bidder undertakes to involve itself in when it submits the bid, will then be followed.
Chair, can I put this to Ms. Hofmeyer for clarity of what is meant by the requirement of the tender?
What she means is it was obligatory that the bidders satisfy the NIP requirement. That's what she's talking about.
Okay, Chair.
She wants to check with you whether you agree that there was such an obligation
Chair.
on the bidders.
As I said, that the guidelines for the NIP obligation from the DTI, it says what is applied on that tender should be put on the tender as the requirement, right? And then the bidders will be aware of what is expected of them when they bid. And then Ms. Hofmeyer takes me to this page. This page is a page coming from the DTI that usually the team from SAT that are running the tender, they copy and paste. In this regard, I would think maybe they didn't think, because this was the first contract that we had applied supply development, just take it out. So no, it is not obligatory and it is not a requirement. I want to take you through the requirement of the tender, Chair, and then hopefully that Ms. Hofmeyer is going to understand how it works.
At this stage, you say it was not a requirement.
It
That's
was
your
not
answer
a requirement.
To her question.
Yes, Chair.
Yes, Ms.
Yeah.
Hofmeyer, do you want her to refer to a page which specifies what the requirements were?
What I'm just
won't take
struggling
long.
with, Chair, is this is Appendix 13 to the RFB.
Yes.
Right, we see that at the top of the page.
Yes.
It indicates to bidders this document must be signed and submitted together with your bid. And there's a signature page available at 2085. And then it explains, in addition to that, that the bidders are required to sign and submit the standard bidding document SBD5, which is also a document dealing with the NIP obligation. So in fairness to Ms. Mamela, I'd just like to understand how it could be that despite this being part of the RFB, the NIP obligation was not undertaken by bidders.
The NIP obligation, okay. Like I said, Chair, earlier on, that the tender documentation is worked on by the team that are sitting at the CFST team. And of course, sometimes they would need, if I was involved in this, I would have guided them in terms of the guidelines of the DTI, what should be here. And I suspect, although I'm not aware, I suspect that they had put it here in case the supplier development program or supplier development commitment from these multinational suppliers does not come through. Remember, I told you on Friday that most multinational companies or maybe bidders or suppliers of SAT, they have never adhered to the NIP obligation because that was the control and management of the DTI. So now, just like to go through this, it's just 2 pages, Chair, and I'm not going to read everything. I just want to make it clear for Ms. Hofmeyer to understand what is, like when they talk about the requirement of the tender, what elements.
Yes, what you want to read, is it part of the request for bid document?
Yes, Chair, it's part of the tender document.
Okay.
And then I'm going to tell you which page.
Let's go there, yeah.
Yes, it's page 2062.
2062.
2062, Chair.
Okay. Yes.
You will see here, Chair, on this page, it talks about evaluation criteria. And it gives you phase 1. Phase 1, yeah, I said I'm not going to read everything, I'm just listing
Yes.
Phase 1 talks to critical criteria. The critical criteria then is the part where if the bidders don't say yes or no, they get disqualified automatically. So the critical criteria is the first phase. Phase 2, in this regard, I think the critical criteria was mixed with the functionality. Sometimes the functionality does not apply if the critical criteria is here. So phase 2 talks to price and BEE evaluation.
Yes.
And then under BEE evaluation and price, it talks to reciprocal work should amount to 10% of the value of the contract, and it will be based on the following. And then it states what is required from them. And then there is a partnership joint venture, 10%. There is supplier development must form 10% of the contract value, and it must entail the following. It states what is required from the bidder. So when the CFST team does the evaluation, these are the elements they are looking at. They don't even look at the NIP obligation at that time. So that's what I was trying to highlight to Ms. Hofmeyer, that the NIP obligation does not apply when supply development is part of the document, and it has been made as the element of the bids.
But you agree that the page to which Ms. Hofmeyer referred you does say the NIP obligation was a requirement?
Well, okay, can I ask
that
Ms.
was
Hofmeyer?
page, what page was that?
It commences at 2083.
2083.
Yes, Chair.
Is my understanding of that part of the
Indeed.
page correct?
Indeed, Chair.
2083.
Yes, that's
Yeah.
where the whole appendix dealing with the NIP obligation begins. But I can give Ms. Mamela another reference that will make it absolutely clear it was an obligation of this RFP. But before I get there, just to clarify, you weren't involved in the specifications for this bid, were you?
No.
No. So that is left to the CFST team, as I understand your evidence. They put out the RFP and they defined its criteria, correct?
Chair, it's not up to the CFST members to decide what the criteria or maybe the requirements are in terms of the NIP obligation.
Well, your evidence suggested that actually you were saying when it comes to how they dealt with the matter, they dealt with the matter in a manner that showed that as far as they were concerned, the NIP obligation, the NIP requirement was not an obligation. That's how I understood your evidence.
The evidence earlier on.
Your evidence.
The evidence. Remember, the evidence, Chair, was talking about the requirements of the tender. So I want to clarify that confusion.
But the question is this. Page 2083,
Yes, Chair.
and I've just had a look again, that first paragraph, makes it clear that after the cabinet decision referred to therein, all state and parastatal purchases, lease contracts for goods, works, and services entered into after this date, that is 30 April 1907, are subject to the NIP requirements. That's what it says.
That's what it says, Chair.
Now, something is not a requirement if you can dispense with it.
Chair,
That
this,
suggests that it's obligatory. That's how I read it.
yes,
So I want you to say, is that how you understand this as well, irrespective of whether in practice it was applied? But is that how you understand this?
the understanding, Chair, as I said, this is coming from the guidelines of the DTI in terms of the NIP obligation.
Yes.
And it's copied and pasted on these things. So it's.
But do you understand it the way that I understand it?
I understand the way that you understand it when it talks to the multinational companies alone with no application of supply development.
Okay.
Yes, Chair.
Okay, but do you agree that in this paragraph that we are talking about,
Yeah.
no distinction is made between multinational companies and companies with supply development? Do you agree with that?
In this document, I agree.
You
Chair.
agree with
Yeah.
that? But you rely on something else to
I
say.
rely on the proper legislation from the DTI that gives differences between the supply development program, which is under the indirect NIP obligation,
Yes.
versus the NIP obligation.
Okay, all right. So Ms. Hofmeyer can take it from there.
Yes,
Yeah.
I'll draw your attention to the earlier provision of the RFB that made it very clear that it was a condition of the proposal that bidders comply with the NIP obligation. So I'm not relying simply on Annexure 13, which I understand your evidence to be as a cut and paste from something from the DTI.
Yeah.
Let's see what the people who specified the conditions of the bid
Which page?
required. It's at 20447. You'll see there's a clause on that page 1.2. Can you read the heading of that clause?
You said 2047, right?
2047, and you'll see it starts with the heading conditions, and then there's a 1.1 and a 1.2. Do you see that?
1.1 and 1.2, yes.
Yes, what's the heading of 1.2?
Condition of the proposal.
Right, and read 1.2.1, the first sentence, please.
This bid is subject to an offset obligation under the National Industrial Participation requirements mandated by the South African Department of Trade and Industry.
Thank you.
Can I continue? Because I
Yes,
have
sir.
mentioned direct NIP and indirect NIP, Chair.
Oh, certainly.
Yes. Direct NIP, it says in inverted commas, which is used in procurement where there is potential to develop or support direct strategic industries. Or indirect NIP, which is used in procurement where there is no potential for local manufacturing or supporting strategic industries, and is to be applied to this bid as one of the 4 tiers of procurement.
Yes, so unless you tell me otherwise, Ms. Mamela, I read this to make it absolutely clear to bidders. This bid is subject to the offset obligation under the NIP, and then that is followed up in Appendix 13, because the details of the NIP program are set out, the obligations of the bidders are made clear. You have to immediately alert the DTI after you are successfully awarded the bid. So in that whole conspectus of this RFB, can you indicate to us why you still maintain that it was not a requirement of the RFB?
Chair, I think either Ms. Hofmeyer is not understanding what I'm trying to point out. In the provision that she asked me to read, it talks about indirect versus direct NIP. Direct NIP, that's where it's between the multinational company and DTI. SAT does not get involved. An indirect NIP, it could be like under 4 tiers, and it could be through supply development and through other elements that I don't remember right now. But I'm just trying to say, still, this does not say, okay, the NIP obligation, the direct part of it, should have applied here, because they are actually saying to the suppliers, either or. And then they go as far as giving the suppliers the link to the DTI. This is when the suppliers are going to find out that you cannot apply both supply development and NIP obligation both, because like I said earlier, the supply development is managed and controlled by the SOC versus the direct NIP, which is managed and controlled by the DTI. SAT does not even take, in fact, they deal with DTI immediately after the tender has been given to them, and then DTI is notified that, okay, these guys are the ones that have been awarded, then the DTI is going to deal with them. Yes.
But,
so I'm hoping that I'm clear this time, sir.
Yes. The NIP provisions.
Yes, Chair.
You say this is a reference here to direct NIP and indirect NIP.
Indirect NIP, Chair. So the direct, yes.
But the provisions would be the same. The difference would be which one is regarded as direct, which one is regarded as indirect.
The provision are not necessarily the same.
Yes.
Because on the indirect NIP, it
Yeah.
gives back the BEE points to the
Yeah.
SOC, where
Yeah.
they now calculate that, okay, I actually mentioned this on Friday.
Supply development.
Yes, under supply development. This is what the local supplier or black-owned supplier is going to gain
Must
or
do.
benefit out of this. I even made an example, Chair, of the tire agreement. For instance, that maybe it's shipped from Brussels to Durban, and then they could agree or make an arrangement that, okay, the local supplier to, to benefit out of this contract. They will be then transporting the tires from Durban to SAT, right? And I even added that other elements of the supply development are through job creation, and then also the others are transfer of skills, know-how, and technology. So that now is indirect NIP obligation, Chair. And then the NIP obligation is the one that is mentioned in the page where Ms. Hofmeyer was reading for me. Exactly. That one is direct, and it's dealt with by DTI and the multinational companies. SAT has nothing to do with that.
Yes, SAT would be involved with an indirect NIP.
Thank you, Chair.
But when we talk about a NIP obligation, it could be either or. It could be either direct or NIP or indirect.
Yes, Chair. Hence I was
But
saying-
whether it's a direct or indirect,
Yes, Chair.
it would be obligatory. Is that right?
It will be obligatory.
Yes.
Which in this regard, remember I read for you the elements of
Yeah.
this tender which involved the supplier development,
Yeah.
which counted 10%.
Okay.
The direct NIP, Chair, Ms. Hofmeyer didn't read that. I don't know if it's in that document, but the direct NIP charges 30% of the contract. Yes, and then on the supply development, because I even mentioned to you that I did not apply, or maybe my team did not apply that 30% set aside. Therefore, like they were saying, 10%, that's where they will be evaluated upon.
Okay. Ms. Hofmeyer.
Are you aware that SAT engaged with the DTI after this agreement was concluded in about March of 2019? Were you aware of that evidence of Mr. Human?
March 2019, Chair, I was not at SAT. So I'm not aware who and how DTI was approached, but I do know that for the tire tender contract, I did approach DTI for the CCMA case and ask them the difference between the direct NIP versus indirect NIP. I remember the DG of the NIP obligation actually took me through the processes that is followed and even explained that you cannot apply both. You apply either or. the other.
Okay.
And Ms. Mamela, are you aware from Mr. Human's evidence that the DTI responded to SART, asked for the bid, the RFB, asked for JM Aviation and AAR's bids, and concluded that either SART or JM Aviation ought to have immediately alerted the DTI after they were awarded the tender pursuant to their NIP obligations?
I am not aware of that, Chairperson.
There is an affidavit to that effect from the DTI included in Mr. Human's annexures. We'll go there in a moment if we can. But before we do that, I just want to complete on the RFB because we're in that document. It's in Exhibit DD 22E. Ms.
Chair,
Mamela.
are we still, are we closing up on NIP? Because I don't want us to leave. There's this part that you've raised
Sure, I'll
talks
take you to
about
the
Mr.
DTI
Human.
affidavit.
Yes. So I want us to close that.
Yes, no,
so that
she'll
like,
take
whoever
you.
is watching this understands exactly how it works.
Yeah.
Okay, so the DTI affidavit is in Exhibit 22G. It's one of the files of Mr. Human's evidence.
22G.
Yes.
22.
G.
Oh. Page.
It commences at page 2972. Chair, that is where the affidavit of Mr. October commences. That's 2972. The relevant paragraph to which I was making reference in my question to Ms. Mamela appears at 2975.
Mr. October, we must put it on record, Chair, that Mr. Lionel October is the DG, Department of Trade and Industry, does not state that he is the DG for NIP obligation. So which page you said I must go to?
I'm not sure what to make of that response. Are we to disregard what he said in this affidavit?
No, I'm not saying that. I'm not saying that, Chairperson. I'm saying, remember, for each and every department in our government, there is a certain person who deals with a specific subject.
Okay, no,
Yes,
hang on.
Chair. So
hang on,
I just thought
hang on,
I should put
hang
that
on,
on
wait
record.
until you hear what question you are asked.
Okay.
And then if you need to emphasize that in answer to the question, then you can emphasize. But let's hear what the question is first.
Chair, the question was I aware that Mr. Human or whoever from SAT had communicated with the DTI, and then there is communication that says JM Aviation should have notified SAT or SAT should have notified SAT. Yes. So
But
that was the question.
I thought that we are coming to this affidavit
Indeed,
because
yes.
Ms. Hofmeyer wants to ask a question on this affidavit.
Yes.
Okay.
So
of Mr. October.
Ms. Mamela had requested us to be taken to the affidavit, which is why we're going there. And the relevant paragraph is at 2975 at paragraph 15. There's some background that's been set out by the Director General of the DTI prior to that, talking about NIP obligations, how they work in the tender process, etc. And then at paragraph 15, Mr. October says, as advised in paragraphs 3 and 6 supra, whenever a NIP obligation is created by virtue of a purchase agreement between a procurement entity and service provider, as in the present instance between SART and JM Aviation, there is an obligation on both the procuring entity as well as the successful bidder to inform the DTI of the purchase agreement. In this regard, one may note that the National Treasury Practice Note is addressed to all accounting officers, all accounting authorities, all chief financial officers, all heads of provincial treasuries, and all provincial accountants general. In paragraph 5.1 of the National Treasury Practice Note, accounting officers and accounting authorities are required to utilize the revised standard bidding document for NIP obligations, SBD 5, when inviting bids that are estimated to be in excess of 10 million rand. Chair, I just pause there because you'll recall when we were in Appendix 13 of the RFB, there was specific reference to the fact that the bidders had to complete the SBD 5 form. Then it goes on to say, according to paragraph 5.1b, accounting officers and accounting authorities, quote, are required to furnish the DTI with the information listed in that paragraph after the award of any contract that is in excess of 10 million rand. The DTI's contact details are then set out. And importantly, he says, paragraph 5.2 provides that the information must be sent within 5 working days after award of a contract. So, Ms. Mamela, you asked to be taken to where it was that the DTI's Director General had made it clear in his evidence before this commission that there was an obligation on both SART and JM Aviation within 5 days of the award of the tender to them to alert the DTI to the fact that the agreement had been concluded. Are you satisfied that that's his evidence?
Chair, in his affidavit, Ms. October is addressing both the direct and indirect NIP obligation, as I was saying earlier. And he goes as far at the end, because now before that he's talking about 10 million or over 10 million and whatever. But he goes as far as saying under paragraph 19, in the present instance. Of course, he's not clear, but remember, we might interpret this differently based on what he's written here. But for me, this statement says, after he has stated exactly what is expected of the bidders, multinational bidders in terms of the direct NIP obligation, to notify the DTI or the accounting authority, which is the board, accounting officer, which is the CO, to notify DTI on the direct NIP obligation. But on this instant, in the present instance, meaning now he understands that it's not the same NIP obligation, because this one, the supply development applies. Therefore, he even says it was the obligation of JM Aviation, being the local company that is benefiting from this supply development. They should have notified DTI, not because DTI is going to manage or control them, but at least they will have a record. And of course, this should be managed by SAT, but they will have a record that the reason why the direct NIP obligation did not apply, there was indirect NIP that involved supply development. So that's my understanding of the affidavit, Ms. Hofmeyer, based on the background I have on the NIP
Ms. Mamela, the difficulty is that nowhere in this affidavit does Mr. October draw this direct-indirect NIP contrast. He doesn't refer to supply development. What he says in paragraph 19, in fact, and I'll read it into the record, is, in the present instance, despite the fact that there was a duty on JM Aviation to immediately inform the DTI that the particular contract was awarded to it, it failed to inform the DTI. That's what he's saying in paragraph 19. He's previously told us that there's an obligation. He's sketched what it is. He said it has to be done in 5 days. And what he says at 19 is he tells the reader what happened in this case. What happened in this case is, despite the fact that there was a duty on JM Aviation to immediately inform the DTI that the particular contract was awarded to it, it failed to do so. Do you read it in a different way?
It looks like you read it in a different way in terms of understanding the NIP obligation.
No. What she's asking is whether your reading of it differs from her reading of it.
Yes, it differs from her reading of it, not the legislation.
Right.
Yes, or the guidelines that are guiding the NIP obligation.
Thank you. Chair, I think we've exhausted the NIP obligation.
Yes.
If we can go back to the RFB, because there's another provision of the RFB that concerned that was breached by JM Aviation.
Chair,
There seems to be a problem.
I want to add just one statement.
Yes, okay.
Remember, I mentioned to you that we had at SAT 3 big contracts: the logistics, the tire, and components, the component that we're talking about now. And then out of these three, the two component was provided by a multinational company with no involvement of local company. The tire was provided by Bridgestone, being based in Brussels, without any involvement of local company. The NIP obligation had always involved them because they're dealing with that. But the logistics, it was provided for by KWE, being the South African company. By virtue of that, them being the South African company and having the BEE points and stuff, they did not have to adhere to the NIP obligation. And as a result, there is proof that the DTI did not even approach or expect the KWESA to adhere to the NIP obligation because they were a local company. So that's what I was trying to explain to Ms. Hofmeyer, the difference between direct and indirect NIP obligation. We can close, Chair.
Let's go back to DD22E, if we may, because that's the document that contains the RFB. And
DD?
E22E, which had the RFB that we were looking at.
The one that we were looking at before.
Yes.
DDB or E?
E. And pick it up at page 2054, if we may. (2054) of Exhibit DD22E. You'll see there, Ms. Mamela, there is a clause 1.13 headed corruption. Do you see that?
Yes, I see that.
And this was a provision of the RFB that said the following. If a bidder or any person employed by the bidder is found to have either directly or indirectly offered, promised or given to any person in the employ of South African Airways Technical any commission, gratuity, gift or other consideration, South African Airways Technical shall have the right, and without prejudice to any other legal remedy which it may have in regard to any loss or additional cost or expenses, to disqualify the RFB bidder from further participation in this process and any other subsequent process in this regard. And then it goes on and records the RFB bidder will be responsible for all and any loss that South African Airways Technical may suffer as a result thereof. In addition, South African Airways Technical reserves the right to exclude such bidder from future transactions with South African Airways.
Yeah.
Do you see that?
I see that.
Now, what concerns me about this provision is that it prohibits bidders or any person employed by the bidder to either directly or indirectly give to any person in the employ of SART any commission, gratuity, gift or other consideration.
Yes.
And I'd like to put to you in the context of that prohibition,
Okay.
why it wasn't that when JM Aviation paid indirectly for your benefit, because we traversed that on Friday, you accepted that it was indirect benefit, that 2.5 million rand. And they paid that to you, an employee of SART, to purchase your Bedford View house. Why would that not be in breach of this provision?
Chair, I still maintain, and the reason why I corrected Ms. Hofmeyer on Friday when she said direct, and I said indirect, I maintain that there was no benefit with regard to this tender. The reason why I say that is because the agreement to sell the property of my mother and to Mr. Nzegu had nothing to do with me, other than that the sum of the deposit being 1.5 was going to be paid to the Coveridge property. Contrary to what Ms. Hofmeyer keeps on referring to the Bedford View. Of course, like that happened after I had changed my mind about the Coveridge property. Now, the reason why I am saying there was no benefit, direct or indirect, is the fact that I did not sit in the bid evaluation committee. I did not sit in the board that made the decision to award to AAR and JM Aviation. I I did not reciprocate.
Well, not sitting in the board or in the committee wouldn't affect the question of whether there was a benefit or not to you and whether it was direct or indirect. Not sitting may be a point to say there was no problem because I didn't have decision-making powers, which you have said before.
Yes, Chair.
But I think your answer, you are supposed to deal with why was this not an indirect benefit to you?
It was not an indirect benefit to me, it's because I had never reciprocated the JM to have a winning bid, either in GPU or in component. Ms. Hofmeyer does have evidence that the submission that was made as a recommendation to EXCO, to BAC, initially it said Lufthansa being the highest preferred bidder. Remember, Ms. Sambo put it out there to the public that Nontsasa Memela helped JM to be the winning bidder. I had to correct that. The winning bidder was Lufthansa because it was a highest scored bidder. And because of certain risks that were picked by the board or maybe the CFST, it was returned back. And then the second one was Air France, based on the points that were put by the CFST, that, okay, the risk will be if we start with any other company that has never dealt with SAT before. So we would rather appoint or award to Air France and Kwane Capital at that time. Now, I said to you, Chair, I had signed in support of the recommendation by the CFST. Meaning I was satisfied with what they had said to me that, okay, the reason why we're going for Air France is because of this. So the reason why I'm saying there is no direct or indirect benefit or gratification towards me, because I did not sign any tender that was giving AAR and JM in 2016 saying they must win this. We signed the recommendation for Air France, and then the board made its own independent decision to say, I see management, CFST, you have recommended this, but from us as the accounting authority of this organization, this is what we think should happen. And then they overruled the recommendation by the CFST and management of SAT and awarded it to JM Aviation.
Yes.
Chair, just one follow-up question, if I may, and then it might be a convenient time to talk about logistics. Ms. Mamela, this particular provision of the RFB doesn't link the benefit to any possible influence that it may have on the recipient. Do you see that?
Are you okay? Can you ask the question again?
Sure. I understood your answer to be it's not a benefit because I did not reciprocate. Was that your evidence?
That's the evidence.
I say this clause of the RFB doesn't require it to constitute corruption under this clause, that the benefit then be reciprocated or the benefit result in an ability to influence decision-making. On its own terms, it is a clear prohibition on any bidder, directly or indirectly, giving a gratuity gift or other consideration to any person in the employ of SART. And I'd like to know why, if you contend this provision was not breached by the 2.5 million that was used for your Bedford View house, why it is. And let me just be clear, your answer till this point has drawn focus on reciprocation. I'm saying reciprocation has nothing to do with this provision.
Chair, it's read very clearly that it talks to gratification, gift, gratuity, gift, or other consideration. None of these apply to me because there was no gratification, and I explained the reason why. I explained why there was no gratification. I was getting to this, and there was no gift coming from the bidder directly to me, so that like they can win the tender or do anything. I did explain earlier on, Chair, that the offer to purchase, like, which the Commission will see eventually either from Mr. Nzegu or after I had gone to Eastern Cape to send it afterwards, they will see that like that offer to purchase was signed November 2015. And the fact that Mr. Nzeku through JM paid in May 5 does not make the gratuity to me or the gift. It was still paying for that property that was bought from my mother. And secondly, Chair, the award was made by the board, I think, on the 12th of May, 2016. Remember, Ms. Hofmeyer is trying to link certain dates because the payment was made on the 5th of May. And then the award by the board was made on the 12th of May, 2016. But she did not add the fact that the contract commenced in October 2016, way after the award. So in case like maybe there is a picture that is being put out there that, okay, they must have used the money from here that they received from SAT to pay for the property for my mother and stuff like. So I just had to hoy in the date when the contract commenced, which is all the suppliers get paid after they start providing services.
Ms. Hofmeyer.
Chair, I'm just mindful of the time. We've hit 5 o'clock and you indicated that you were happy to sit late.
Yes, but we now have a good idea that Ms. Memela may have to come back because she and her legal representative are still going to consult an expert. So we have one option is that we stop, and then when she comes back at a time when they have been able to consult an expert, and then she continues and until she finishes. That's one option. Another option would be that we can continue maybe for another 30 minutes, but it may be that it won't serve much purpose to continue for another 30 minutes if she's going to come back anyway some other time. But it may well be that in terms of your plan, it might help you to close off something. What do you think?
Chair, I want to propose that there's maybe a third option, if I may. Certainly the debates between experts may actually resolve themselves.
Yes.
You know, that's how the experts usually one side, they look at, they give a report, and then if there isn't a dispute between them, because the expert evidence is very limited. It's simply, does the metadata show what the Commission's investigators has said it's shown? All that I'm reluctant to do is delay all of the evidence in completing of Ms. Memela for a situation where there may be agreement between experts. We just don't know. So I wanted to say in relation to finalizing her evidence but for the expert engagement, which must certainly take place. You'd indicated that we could continue for 30 minutes. My concern with that is that Ms. Mbanjwa has already indicated that she'd like to re-examine. And my sense is that that will not be completed this evening.
That won't be
So our proposal, Chair, is really the following. If it would be possible to start a bit earlier tomorrow, we could then complete Ms. Memela's questions from our side. We could then move to the re-examination that Ms. Mbanjwa wishes to do. And then once that's completed, subject to other clarifications, we would move to the evidence of Mr. Nzeku. I've already spoken to Mr. Nzeku's legal representatives, and they indicated that they would be able to start early tomorrow. I can't recall whether I asked Ms. Mbanjwa about that, but we can get her views now. Our proposal from the legal team side would be we reconvene a bit earlier tomorrow. We seek to conclude Ms. Memela with the re-examination tomorrow and hold off on experts because it may be resolved and she won't have to come back. We then move to the evidence of Mr. Nzeku, which, Chair, I'm fairly confident we would complete tomorrow but possibly with a bit of use of the evidence on Wednesday. We had been in touch about the possibility of slotting another witness in on Wednesday, but unfortunately I can report to you that his legal team is not available on Wednesday. So we actually do have Wednesday morning, to the extent that you're available, Chair, to then conclude Mr. Nzeku's evidence. And it would be our submission that we then conclude this aspect of the investigation, and it would be in the interest of the Commission to do so.
Well, let me check with Ms. Memel and then I'll go to Ms. Mbandwa. Would your situation permit you to be back tomorrow? I know that you made special arrangements to be available today.
Okay, Chair, after my lawyer had mentioned to me that she would need extra time to go through certain documentation,
Yes.
including the policy of the company, certain legislation and stuff, so before she can start with her re-examination.
Re-examination.
Yes, so I had already postponed my trip again to
Oh,
Eastern Cape, so
okay.
I will be available.
You would be available
tomorrow.
tomorrow.
Yes,
Oh,
but I'm not sure about the early part of
Yes,
it.
yes, yeah, we'll talk about that now. Ms. Mbandwa, what do you say to this suggestion?
Firstly, Chair, I may have difficulties. I don't know how early it is. Maybe that should be.
Well, she's leaving it to me, that's why she hasn't said.
Oh,
She hasn't said.
No, no, it's just that the reason.
Well,
Chair,
I'm thinking that. Well, actually, Ms. Hofmeyer is listening. If Wednesday's witness is not going to be coming, and therefore Wednesday morning is available for Mr. Nzegu to finish if he doesn't finish tomorrow afternoon, I wonder whether there would be a need to even start early tomorrow morning. From your side, how much more time do you think you might need to finish your part before Ms. Mbandwa re-examines?
Chair, if
I
it
know
was
that,
only me,
Yeah, I know that Ms. Mamela will.
and that's me in a room
but
without the
she'll be
Chair,
very
Ms.
crisp
Mamela or
tomorrow.
Ms. Mbandwa.
She will be very crisp tomorrow.
I will be
in her
crisp
answers.
tomorrow.
Yeah.
Shouldn't be more than half an hour then, Chair.
Yes, okay.
Yeah.
Well, in that event, it doesn't look like, Mr. Mbandwa, you can come. It doesn't look like we should really need to start early. So maybe we should just start normal time, 10 o'clock.
Yes,
Would that be fine with you, Ms. Mbandwa?
yes, no, that would assist.
That would assist, yeah.
Chair.
Yes. Okay. No, that's fine.
Chair, sorry, I've just had an indication from Mr. Nzeku's lawyers.
Yeah.
They're a little bit concerned about how long Ms. Mbandwa anticipates the re-examination might be.
Yeah.
Just insofar as how much time we would lose tomorrow.
Yes.
So maybe it would be useful if she could also give us an indication there. I think they're quite keen to be able to
Yes.
conclude
Ms.
the
Mbandwa,
evidence.
what's your estimation? I won't allow you to have as much as you might wish, but what's your estimate of how much time you might need for re-examination?
We wanted a full day.
I won't give you a full day.
Then if we don't get a full day, then we'll just take it as far as we can.
You
But
see,
what-
the re-examination contemplated in the regulations, as I understand it, is meant to enable you to just clarify areas where the witness might not have, her evidence might not be understood, you know. So that's why I wouldn't give you a
Too
whole
much.
day. So I think if it helps you, I can tell you that counsel who have re-examined their clients before, I don't remember anybody who has gone beyond 2 hours, if I recall correctly. Mostly it's been under that, if that helps to give guidance. But let's say you get the message from me.
I get the message.
Yeah.
I get
So let's start tomorrow at 10 o'clock. Do the best you can to focus on really areas of clarification, and then we'll take it from there.
Thank you, Chair.
Okay, all right. Okay, so we are going to adjourn for today, and then tomorrow we'll start at normal time, 10 o'clock.
Thank you, Chair.
Thank you, Chair.
We adjourn.
All rise.
Oh, wait, you from